today at NCA's Guide.
So that, because I find that a lot of candidates study constitutional law and more than halfway into, thanks, diet for recording, more than halfway into your study, everything is still, not properly pieced together. It's still just very random and scattered. But if you can see the big picture, hopefully if I can attempt to piece together a big picture for you on our conversation today, when you start a study, you'll have more context. Hopefully it also helps you develop a bit more interest and piques your interest and curiosity so that you're itchy to flip the pages and study. Of course, we offer intensive classes. I believe they now go for $300, 4 sessions, 4 3-hour sessions, and then a 3-hour exam review workshop. I usually struggle to keep it at 4 sessions. Sometimes it spills and we have one additional session just to answer questions and all, but that's typically what we offer. It'd be great to see you at the session, at the intensive classes, where we can have deeper, more detailed conversations around each topic. I am also hoping that everyone on this call is aware that the constitutional law syllabus has been recently revised by the NCA. Okay, before we get into that, let me say real quickly that my expectation is that your cameras and your microphones are turned on, I beg your pardon. I expect that, you turn on your cameras, you turn on your mic. If your background is noisy, then absolutely you can mute your mic. And then if you need to talk or you need to ask a question, then you can turn it on and then say what you have to say. But I do not appreciate speaking to a blank screen with just thumbnails of initials. And I also, expect this session to be very interactive. I'm not a public speaker. I'm a tutor. So I expect to see your faces. It works great for you because I can tell when I've lost you or you're confused or I've said something that you're struggling with. It also helps you make sure that you're engaged and participatory. And then for me, it's just easier. You get the best of me if I can see your faces and I don't feel like a radio presenter. Okay. Hi, it's good to see you here. Okay, I'll give you guys a couple of seconds to turn on your cameras, or let me know if you're unable to, because just one person has turned on their cameras, despite everything that I've said. Asta, I hope I'm saying your name right. I believe you intend to turn on your camera, but there's probably something going on there. Are we all having technical issues with our cameras?
Seun, some of us are shy.
You can't imagine how shy I am as well. Except you want me to turn off my camera as well, and then we just have a voice call. Anyway, I was saying that I expect that everyone on this call is aware that, the syllabus has been revised. And, when I was getting ready this morning, it crossed my mind that some of you guys might have started to study based off of the old syllabus, and then a couple of weeks ago, you realized that the syllabus had been revised. So hopefully we can touch on that. I mean, if you ask me, I think that yes, Owen.
I checked the syllabus. What they call revised, they just rearrange the chapters.
Yes,
it's the same content, the same content, the same cases, the same statute. They just rearrange the chapters, put them in different places. It's the same thing. I checked it.
Sorry, may I speak?
Very few cases they added new cases. I'm not sure up to 5 new cases they added.
Right.
They took away some cases as well. Sorry, I can't turn on my camera, Seun. My name is Ejuke. I have my baby here. She's going to distract everybody. So please, excuse me, please. So I think they removed some of the cases though, and they put some new ones. And yes, you are right there too. They rearranged the syllabus as well. I agree.
the same content A to Z.
Yeah, I think language rights also was taken out completely.
I've always wondered what he was doing there.
Yes, language rights was taken out.
And you wondered in professional ethics too.
Oh, yes, I did. Oh, yeah, you are here to out me. I wondered what he was doing. I mean, for professional ethics, it's still a bit, contextual, but for constitutional law, I've never seen a question in it. There's not much of a conversation to be had there. So good thing they took it. I was going to say, I mean, I completely agree with all of you guys to say that, when I heard that the constitutional law syllabus was revised, I was asking myself, what do you want to do? What could you possibly review in, for constitutional law? It's very set. It's very foundational. So it's not likely that you're doing a thorough overhaul, right? The constitutional system of the country is what it is. It can get modified, as the society or as the country advances, but essentially it will always be what it has always been. But what I was going to say, apart from what all of you guys had said, okay, maybe not apart from, I wasn't going to talk about the rearranging and the cases, because I think it's still essentially substantively the same thing. But what I found most instructive and what I found as a divergence from the usual or from the old syllabus, and I think that, anybody who's taking constitutional law should be aware of, as well, I feel quite passionate about it because anybody who has heard me talk about constitutional knows that I've always said that. I've always, maintained the position that the NCA seem to be capturing now, to say that I'm not the tutor who teaches you, come to me, I'll give you 1 page for each topic and you'll be good. I'm also not the tutor who tells you, this is all you need to know. You only need to know division of powers, and you only need to know charter rights and you'll be good. I'm not a tutor who also tells you not to study your case laws. You need to study your case laws. One-liners won't cut it. The decision of the courts randomly, placed in your brains won't cut it. You need to, and I'm not saying study the 50 pages, of the court decision, but you need to at least appreciate the facts so that you can understand the reasoning of the court that led to, whatever decision the court eventually adopted. And I believe, when I read through the revised syllabus, that was what stood out for me. There was conversation about, in fact, the syllabus went as far as saying, don't study Hogs alone. Because, and I've always said that as well with constitutional law, there's always, Hogs will give you his opinion. He will critique the decision of the court, but you have to be aware that Hogs is a renowned, respected jurist, but he's not on the panel of the justices of the Supreme Court. And so that's what the NCA is trying to touchlight now, to say you must study case laws, right? Yes, absolutely, get scholastic analysis, and then on the, standing on the legs of both sources of information or authority, mold and form your own opinion, and then be able to apply what the decision or what the rule or the principle is to a fact scenario in the event that you get one. If you ask me, I think that that's the most prominent change. That, they took a couple of paragraphs, maybe 6 paragraphs, just, emphasizing the importance of that. I've always maintained that constitutional law, unlike maybe admin law, for instance, where you can have a framework, do this, do that. Constitutional law is very dynamic, depending on the intelligence of who's asking your question or who's drafting the facts. You can get, one line can throw you completely off balance if you just have everything crammed or memorized. You have to deeply understand the concept, deeply understand the reason, the history for the concept, the reason for why it is where it is at today, and then, you're able to properly position it, to probably position it in applying it to any given set of facts. Okay. So having said that, did any other person notice any new thing with the syllabus that we should touch on before we get into the topics? But essentially, I think that's it. The chapters were, in my opinion, better arranged now, because I've always wondered why everybody seems to be, a lot of people are confused as to what the role of the heads of powers are because of the way they appeared on the syllabus. You'd have reviewed, all the important judicial principles before you start to talk about the heads of powers. But the way that the syllabus, the topics are outlined now, you can understand that, okay, when we talk about division of powers, this is what we're dividing them under. These are the heads of powers. And hopefully we can get into that conversation today. But I believe that is about the revision to the syllabus. So if you had started to study before the revision, all is well. You're not, it's not a waste of time. You probably just need to make a few, mental repositioning. But I don't think that you have lost a lot of time in terms of the context or the substance of what you've studied. Okay, so I typically have someone read out the syllabus to me so we can run through chapter by chapter. We'll see how far we're able to go. Now the topics are a bit longer, there are more chapters. Aboriginal rights have been divided into three, as it should have been, divided. Aboriginal rights, title, treaty rights, separate conversations. So hopefully, the revision makes it a lot clearer for candidates. Okay, off the top of my head, I know that the first chapter is, any questions or issues or comments, or anybody willing to turn on their cameras now?
I think what I still observed was that they pigeonhole the cases for each one. When they put on that chapter, when they put freedom of conscience, they will just bring like 3 or 4 cases. So I believe that they are telling the candidates, these are the cases they want us to refer to.
Yes, I hear you, and I believe that the old syllabus had something of that sort going on. But I also always say that absolutely, if you have a case mentioned on the syllabus, definitely, I don't know what would be a stronger indicator to you that you need to review that case, right? But having said that, constitutional law is such a broad conversation that you don't want to limit your study to just those cases that were highlighted in the syllabus. I'm not an advocate for studying extensively eventually or overly extensively. Eventually, what we all want to achieve is to pass. But you also, need to do a bit more digging. You also need to go a bit deeper than the surface for you to have proper context, because you never know what the scenario question would be. It might be a question that is not properly aligned with the cases that we specifically pointed out on the syllabus. Yet there is a case law for instance, the recommended text that is perfectly aligned with that, So there's absolutely no way, if I were marking, that you would get your full marks if you don't reference that other case and your argument is that, but it wasn't mentioned in the syllabus. It means you didn't study extensively. Okay.
So are we still good to go with the current notes, since there's different notes of authors? Are they still good to go?
Well, I'm reluctant to speak on notes, but off the top of my head, absolutely. I believe that there's just one new case that I think everybody should pay attention to, and that's the greenhouse carbon emission case, the 2020
this year. Yes.
Or 2020. Was it
decided this year? The Supreme Court decided it this year between the provinces and the federal government.
So absolutely, you want to, if the note you're using doesn't have that case, you want to at least print it off of Google or Canly and include it to your material, or look for a material that has a good summary of that case. But that case is very important. I thought it was last year, because one of my diets last year, we had reviewed it a lot, but I agree with you, at the time it was at the
Court of Appeal last year, then the Supreme Court this year. Supreme Court this year, Court of Appeal decision last year.
Yeah. Okay, so off the top of my head, our first chapter is sources and nature, or nature and sources of the Constitution. I believe I'm correct. And depending on how engaging you guys are, this topic can take on our entire 1 hour, 2 hours, together. But I'll try to keep it brief. Like it sounds, sources is where something is derived from, and the nature of anything is the form, the structure of that thing. So when you see sources and nature of the Constitution, what we're trying to understudy is what informs, the Constitution of Canada, and what is the form, how does the Constitution of Canada present, right? And then before we get into that, of course, once you start to study, the big question or the big picture is that definitely the fact that we're studying constitutional law in Canada means that Canada, runs or operates constitutionalism as a system of government. I will not take for granted, the fact that everybody should know what the meaning of constitutionalism is. So I'll speak to it a little bit. And constitutionalism is just a system of government where actions and laws of all arms of the government are, regulated and must be consistent with the Constitution. Does that make sense? All laws enacted by, whatever arm of government is responsible for enacting laws, and all actions of all the arms of government, judiciary, legislature, executive, all the actions of government officials or arms of government, government agencies must be consistent with, excuse me, I'm getting pop-up that my network is bad. Hopefully we have a good session and there are no network issues. Let me know though if you lose me at any point. So I was saying that, the constitutionalism dictates that all laws enacted and all actions of government officials or government agencies, the government must be consistent with the Constitution. That presupposes that, there is a law or a body of laws that have been, or that has been collectively agreed upon to be the Constitution, to be the supreme law, to be the ground norm, right? To be the basis of governance in a country. Does that make sense? And so constitutionalism says if we're all agreed that this body of laws or this law is the yardstick for measuring everything that we do, then everything that we do must be consistent, must not contravene the provisions of this body of laws. Are we good? So that's constitutionalism. And clearly, constitutionalism is very operated in Canada. And that's the reason we're all here. That's the reason we're reviewing constitutional law. That's the reason we're trying to understudy the Constitution, to understand what it says, what it doesn't say, and then to bring that understanding into analyzing, laws enacted by the Parliament and the provincial legislatures and governmental actions or governmental acts, to say that. And the reason this is important, the reason constitutionalism is a fine governmental principle, is that we're all aware that, government wields powers, right? The government usually is a select few, crop of persons from the larger public or larger community that are empowered to run the affairs of the rest of, of the society or of the state. And so these guys have powers. And one of the earliest, governmental or sayings I learned in government in secondary school or high school was power corrupts. Absolute power corrupts. Absolute power corrupts.
Absolutely.
I didn't hear your ear, but I read your lips. Power corrupts, absolute power corrupts, absolutely. And so constitutionalism steps in to recognize the power that government has, but to ensure that, absolute power doesn't come in, so that the government is, even though supreme, but answerable to a more quote unquote, or the government is superior, but the Constitution is supreme. So the Constitution checks and balances acts, of the government. So that really is, like the reason for everything we're doing. So when you talk about we're reviewing a law, judicial review, what that is, and of course it's the court that typically will undertake that process of measuring or applying the yardstick. First of all, they interpret the Constitution to say, this is what the Constitution says. This is the ambit of the power, the scope of the powers that you have according to the Constitution. This is what you've done. And then the court holds both up to say, this is the power you have, this is what you've done. Did you step out of your power, which would be, the Latin term ultra vires, or did you act within the scope of your powers, which would be intra vires? And that is essentially everything we're doing, whether we're talking charter review. Charter review is just saying the Constitution provides for charter rights. Government, you have to respect and comply with these charter rights. Now you have enacted a law, or now you have, passed a law, drafted a policy, or carried out some act based on a law that you enacted. Was this action respectful of the citizens' charter rights? You see that? Or we're talking judicial review and division of power on federal grounds. What they're saying is that the Constitution provides for federalism, a level of government A, which is the federal level. You have XYZ type of powers. Provincial government, you have ABC type of powers. Now you have enacted B law, federal government. B is clearly not part of your XYZ powers. B belongs to the provinces because the provinces are ABC laws. That's essentially everything we're doing. That's the big picture. So everything that you're studying, you want to ask yourself, where is this found in the Constitution? How has the courts interpreted, or how have the courts interpreted this provision or this power? Now, having understood that power, you want to be able to apply it to this action or this law that was passed allegedly on the basis of this power. Have I confused you guys? Is that a mouthful, or do you have a bit of a sketchy framework at least to start? And so we go into the sources and the nature of the Constitution. I try to keep it very brief. Of course, in terms of sources, we all recognize that Canada used to be colonized by Britain. And, of course, Britain was responsible for drafting the laws and, largely responsible for governance within Canada as a British North American colony. And then you had one of the most significant and earliest laws, in terms of constitutional law in Canada is the British North American Act of 1864. Thank you, right? And, that was enacted by the Privy Council.
1867, not 1864.
67, I beg your pardon. 1867, and that was enacted by the Privy Council of the UK for Canada. And whilst, it recognized and impacted some autonomy, on Canada, the focus of that legislation or that act was not independence, was not complete autonomy from the colonial master, from the UK. But it is a very important body of law. It is now called, it's no longer called the BNA Act, it's now called the Constitution Act 1867, pursuant to or by virtue of Section 52. Anybody read Section 52 of the Constitution Act 1982 yet? Section 52 defines the Constitution and lists out, the documents that have been conferred with constitutional status. And of course, the BNA Act or the Constitution Act 1867 is one of those documents. Now, for the purpose of our conversation, the most significant thing that the Constitution Act 1867 contributes to the constitutional jurisprudence in Canada is that it establishes federalism in Canada. Are we good? Whilst that was not expressly spelled out, like there was no opening statement or preamble that, expressly declared Canada to be a federal state, the imports, right, of Section 91 and Section 92 of the Constitution Act 1867 is that Canada operates a federalism. Because what is a federalism? Anybody wants to tell me what a federal state is? What federalism is? Aaron, hi. You were the first on my call. I haven't seen or heard from you. You didn't even say hi to me. Are you there? Do you want to tell me what you recollect of a federal state? I'm sure we all learned that years and years ago. Hi. We cannot hear you.
Hello.
Yes. Hi.
Sorry. Yeah. First time I'm learning about this stuff, so I can't answer the question.
Oh, fantastic. And that's fine, right? That's fine.
Yeah.
If I'm calling you to ask you a question, it's not because I'm putting you on the hot seat. I'm just trying to ensure that you're engaged. So it's okay to pass. And as we get comfortable with ourselves, you see that you can nominate someone. You can just look on the list of participants and call anybody that you like to answer the question on your behalf. Do you want to give that a shot, Aaron?
Sure. I can go with Asta, maybe.
Sounds good. Asta, hi.
Hi. Hi.
Did you get the question? Would you like to?
Yeah, about federalism. I think it's when you have a central government and a state government.
Fantastic.
The power is divided between them.
Fantastic. Thank you so much, Asta. That's essentially what federalism is, or when you say that a country is a federal state or operates a federalism, what essentially is going on there is that governance has been divided into two levels. For whatever reason, typically it'd be for ease of governance, right? So that, and then typically it would be for ease of governance and then to avoid concentration of powers. Because again, like I said, power corrupts, absolute powers corrupts, absolutely, right? So to avoid concentration of powers and to ensure ease of governance, particularly at the grassroots level, you'd have a system of government called federalism where powers or governance entirely, generally, is divided, between levels of government, typically two levels of government. In Nigeria, I believe we have three levels of government. We have the federal, we have the state, we have the local. But typically, like you'd have in the US, I believe Australia as well, it'd be just two levels. You have the central or federal government, and then the state or regional, provincial government. So what we have in Canada is the federal government and the provincial government, right? So even though there is no text in any of the constitutional documents of Canada that expressly declares, Canada shall be a federal state, if you read 91 and 92, sections 91 and 92 of the Constitution Act 1867, the import of it, what it infers clearly is that powers are divided between the federal government and the provincial government. If you read 91, it says expressly the legislative powers. And the reason that is because, again, Canada was colonized by the UK. The UK, as we all know, practices a system of government called parliamentarianism, where the parliament is king, is supreme. And so, of course, we can still see the influence or the incursion of the influence of, the UK on Canada. And that is why, 91 and 92, or generally when we speak about division of power and the fact that Canada is a federal state, the emphasis usually is on legislative powers. Does that make sense? It also, doesn't do too much damage to the idea of federalism, because as we're also all aware, Canada practices responsible government, which means that pretty much the executive arm of government is practically subsumed into the legislative arm of government. Are we clear? Does that make sense? Have I thrown you off? Feel free to interrupt me. You find that I'm not that polite as well. I would jump in on you. I'm more, my aim is to ensure an interactive, engaging session, because that way I'm sure that if you speak to it, most likely it stays with you for forever, or at least until you have to write the exams, right? So you see 91 opens up and says, XYZ is these are the subject matters that the federal government, if you're inclined to, and you're able to quickly pull up 91 and 92 of the Constitution Act 1867, I don't mind us reading at least the first few lines of both sections so that you can see what we're talking about. And then if you have it, just interrupt me and I'll give you a minute to read to everybody. So the input of 91 and 92 of the 1867 Constitution is that Canada is a federal state. And that is where we get division of powers from, to say that all legislative powers in Canada have been exhaustively, right? So there are no random highfalutin, fluting powers anywhere. All powers have been exhaustively and exclusively divided between both levels of government, between the federal government, which you'd find properly captured in the provisions of Section 91, and the provincial government properly captured in the provisions of Section 92, right? And then there's a whole mouthful of conversation to have around that, but I'll keep that until we start to get into maybe chapter 4, where we're talking judicial interpretation and division of powers. But as far as chapter 1 conversation we need to have under chapter 1 goes, is that, in terms of sources, in terms of maybe just even history and nature, this is a very significant contributor to constitutional law in Canada, the 1867 Constitution Act, right? It provides for federalism. Some of the critics of that document has been that, of course, it didn't provide for amending procedures. And that largely meant that, Canada still had to consult with the UK, still had to go back to the UK if it needed to make any substantial changes to its governing laws. Does that make sense to you? When you go back to your materials, you see a couple of conversations on the textbook. You see a couple of conversations. Some of them include the fact that it didn't provide for the government, the office of the Governor General. It didn't provide for the Supreme Court of Canada. Important conversations, but I won't break too much sweat over those. What you need to know is that it establishes and entrenches federalism in Canada, and what that should do to you is that it should be instructive to you in that every time you're talking federalism, judicial review on federal grounds, division of powers, and all that conversation around those topics, your major statutory authority is the Constitution Act 1867. Does that make sense? 1867 is where you have everything that has to do with federalism, right? Now, you also have the, of course, time went by and then we got to the 1982 Constitution. Has anybody been able to pull up the Constitution Act? Anybody wants to read to us? No? Okay, that's fine. So we have the 1982.
Sorry.
What do you want us to read?
Yeah.
I wanted us to read the opening words of 91, Section 91 of the 1867 Act, and then maybe 92 as well.
All right. So, it shall be lawful for the Queen, by and with the advice and consent of the Senate and House of Commons, to make laws for the peace, order, and good government of Canada in relation to all matters not coming within the classes of subjects by this Act, assigned exclusively to the legislatures of the provinces, and for greater certainty, but not so as to restrict the generality of the foregoing terms of this section, it is hereby declared that notwithstanding anything in this Act, the exclusive legislative authority of the Parliament of Canada extends to all matters coming within the classes of subjects next hereinafter enumerated.
Thank you.
That is to say.
Thank you. So hopefully you appreciate, hopefully going in those few sentences or statements, you're able to appreciate exclusivity, you're able to appreciate exhaustiveness, and you're able to see how it highlighted the Senate and the House of Commons, which is the Parliament. Do you see that? So what it is saying is that, it is lawful for the Queen, of course, because we still have the Queen as, a ceremonial figurehead in Canada. So it says the Queen through the Parliament to, enact laws in relation to the conversations listed hereinafter. Do you see that? You also heard Onye, whilst Onye was reading, say something along the lines of, so long as it is not part of what has been exclusively assigned to the provincial legislature. So you see that division, you see that, exclusivity. If it was listed under 91, then it's exclusively competent to the Parliament. And if it was listed under 92, then only the provinces can touch it. Do you appreciate that? That there is the division of power everybody talks about. That there is federalism in operation in Canada. Real quickly, we can, if you're able to read 92 as well, just the first few statements, just to also see, the provincial powers in action, or maybe not the powers, but the way that, their powers were assigned to them.
Okay, so 92 says, in each province, the legislature may exclusively make laws in relation to matters coming within the classes of subjects next hereinafter enumerated. So
you see that. So 91 says you can do this. Parliament can enact legislations in relation to XYZ, and all of the subsections. And then 92 says the provinces can exclusively enact legislations in relation to, the topics listed here on that. So that there is division of powers, that there is the basis of federalism in Canada, right? Remember that we said when we start to get into judicial review and you have legislations, whether real or simulated legislations, and you need to review them for their constitutionality, that is the basis of your review, right? Section 91 and 92 will be the basis of your review, will be the yardstick for which you'll be able to say, okay, this was within the powers that have been exclusively assigned to the provinces. And so if a province enacted this law, then this law is good law. Or this was enacted by the Parliament. However, this topic or this subject matter is competent or has been exclusively assigned to the province. Therefore, the Parliament has acted outside of the scope of its authority. So this law is ultra vires. It is not consistent, with the Constitution, and it is null and void. Real quickly as well, before we proceed in our conversation, if anybody is able to quickly pull up the 1982 Constitution, let's read section 52, I believe. This time, the 1982 Constitution Act. Vera, hi, did you want to read for us?
Nope, not yet.
All right.
Okay, I'll read it. Section 52 of the 1982 Constitution. The Constitution of Canada is the supreme law of Canada.
Can you hold on a bit? Just a minute, please. Thank you. So you see that is the reason we're all gathered. The Constitution of Canada is the supreme law of Canada. Everything that goes on in terms of law and governance, must be subjected to the provisions of the Constitution. And when subjected to the provisions of the Constitution, it must be found to be consistent with. Do you see that essentially establishes constitutionalism in Canada, to say that whoever you are, Parliament, we see that you're superior, flowing from the style of government in the UK that has heavily influenced the system of government in Canada. So yes, you are superior, but the Constitution is supreme, right? So whatever you do or whatever laws you enact must be consistent with the supreme law, which is the Constitution. Esther, thank you. Can you please proceed?
And any law that is inconsistent with the provisions of the Constitution is, to the extent of the inconsistency, of no force or effect.
Now that becomes important when we start. Later on in your study, or if we have the time to get into that, or if you come on the intensive classes, that latter part of the provision of 51(1) speaks to remedies, to say that, okay, we see that the Constitution is the supreme law. We see that the Constitution is the measuring stick. Now we have measured or reviewed this governmental action or this law enacted by the government, and we see some inconsistency, not just some substantial inconsistency, right? What do we do with such laws? Do you see that? Or what do we do with such actions? You see that? And then the Constitution has said that such actions or such laws are, to the extent of the inconsistent, null and of no effect. If you'd please read section 2, subsection 2 of that section as well, real quickly, Esther. Thank you.
It's age okay.
Oh, I'm sorry, age okay.
No worries. So subsection 2, the Constitution of Canada includes A, the Canada Act 1982, including this act.
Yes.
B, the acts and orders referred to in the schedule. And so C.
Let me interrupt you. The acts and orders that are being referred to includes, in your study time, you go to the attached to the 1982 Constitution. It's on Google, right? You'd see that the BNA Act, the Constitution Act 1867, is probably one of the first that was mentioned. Do you see that? And for whatever it is worth, I think it fits nicely into the conversation around chapter 1 to say that the word includes, the Constitution of Canada shall include the following. Do you see that the court has interpreted that word include to mean that that provision or that list that followed is not exhaustive? And so one of the conversations we'll have under chapter 1 is the fact that the unwritten constitutional principles, that the court has recognized and adopted, formally pronounced upon to be part of, the principles that inform or that make up constitutionalism in Canada. Do you see that? Thank you, Ejoke. And then you list out all those, all the documents that are attached to the schedule to the 1982 Constitution. Typically, I'd like to start my conversation from having somebody read 52, because that is the reason we're all here. You need to get that first before you start your study. 52 expressly declares the Constitution to be the supreme law and goes ahead to say any law that is inconsistent with it is null and of no effect. Okay, so going back to the sources and the nature of the Constitution. In terms of nature, we've seen, from the section 52 that Ejoke just read to us, that whilst the Constitution of Canada is written, it is not contained in one single document. Are we able to appreciate that from what Ejike just read?
Yeah.
Because it says it includes, and it goes on to list. If you go in the schedule, there are at least 30 documents going on there. Do you see that? So whilst it is largely written, unlike that of the UK, despite the strong, influence from the UK, Canada's constitution is written, but it's not contained in one single document like you have, for instance, in a lot of other federal states, or states that practice constitutionalism, like the US, like Nigeria. I believe that, I think India as well has just one, document that is, like a lot of, other federal states, the Constitution of Canada is not contained in one document. And that is that, typically in terms of the nature. Now we go to the sources, right? And I was trying to, paint a picture, a history type conversation for you, but let's just get into the heads of conversation so we can get along and save some time. One of the first sources of constitutional law in Canada is Imperial Statutes. And like it sounds, Imperial Statutes are laws or legislations that were enacted by the UK. Once you hear Imperial, you think the Queen of England. You see that? And that's not so far-fetched because, and I'm trying to spend too much on it. It's not so far-fetched because, of course, Canada was colonized by Britain. They were enacting laws for Canada, and what has happened is that some of the, even the 1867 Constitution, right, was enacted by, enacted by the UK whilst Canada was still a BNA colony. Do you see that? So a lot of those, or a few of those legislations that were enacted by the UK, or the Queen, quote unquote, or the Parliament in the UK, have been conferred constitutional status, right? Not all of them. Most of them have been repealed. A few of them, very few of them, are still in operation, but do not have constitutional status. But a very few of them have been confirmed with constitutional status, and they are listed out in the schedule that was referred to in 52 sub 2 that Ejike just read out to us, right? So we move along real quickly. Another source off the top of my head will be case laws. And the reason that case laws, feeds as a source of constitutional law in Canada, again, is that the court are saddled with the responsibility of interpreting the law, interpreting the Constitution. Do you see that? So certainly some significant pronouncements by the courts, do you see that, in case laws or captured within case laws, have been very instructive and, that played a very pivotal role in the way that the jurisprudence of constitutional law in Canada has been shaped. A fine example is the case that is highlighted in the syllabus, secession of Quebec, re-secession. What's that case? Anyway, what had happened there was Quebec was going to secede. Quebec thought they had had enough of the dominion, or the, coming together of all the provinces, and they decided, had a referendum, carried out in Quebec, had people vote, would you like to stay, would you like to leave? And I believe that, the results were very close. I think it was maybe 49-50. 49% had said they would like to leave, and 50% or 51%, whatever that mark was. It was a very close, race there. And then the conversation, or the federal government, had referred a few questions to the Supreme Court to say, see what is going on in Quebec. Is any province able to unilaterally secede from this dominion or from this marriage, this union, right? If they can, what substantiates that type of unilateral secession in our local laws, in the laws of Canada? Is the situation different when it comes to international laws, right? And, can they just up and leave? And in answering, the Supreme Court of Canada had said, Canada recognizes democracy, right? So if one province decides that they want to leave, and they pass a referendum inviting members or residents of that province to vote, and the majority clearly says they want to leave, we will not hold on to them against their wish. Do you see that? And in reviewing those questions and, giving so you need to understand that references are separate from cases, right? References are just, the government approaching the court. There's no issue, there's no dispute yet. Might not even be a justiciable issue, right? But the government just approaches or the parliament and the executive just approaches the judiciary to say, the law, right? You interpret the law. what are your thoughts on these issues, on these governmental issues that are arising? And that was what had happened there. And so the court had said, I mean, there are no provisions within our laws that allow for unilateral secession of any or by any province, but if a province votes and the majority of them say they want to leave, then we have to, we will honor that because we believe in democracy. The Supreme Court had also listed out a couple of other constitutional principles that we now refer to as unwritten constitutional principles. Very important was democracy, federalism, protection of minority rights, the operation of the rule of law. In answering those questions and opening up all those issues, the Supreme Court had highlighted these principles and, pronounced upon them, declared that they are part of, constitutionalism in Canada. Do you see that? And so they refer to as unconstitutional, or rather unwritten principles of the Constitution, unwritten constitutional principles. So you see how that case, is so important. You almost cannot talk about the jurisprudence of constitutional law in Canada without referencing a case like that. And a couple of others. There is the Supreme Court reference as well, where, there was conversation around the composition and the salary, the remuneration of judges or justices of the Supreme Court. And the court had taken the opportunity to go on and on, to say that whilst the Supreme Court wasn't provided for, or, particularly established by the Constitution, we all cannot close our eyes to the fact that, this is such a foundational topic. The independence of the judiciary is so germane to the practice or the operation of federalism and constitutionalism in Canada. And so by virtue of that case law, the court was able to pronounce upon and include independence of the judiciary into, constitutional law, quote unquote, confer constitutional status on a principle or a concept like independence of the judiciary. So hopefully you appreciate how case laws form a source of constitutional law in Canada. Another fine source off the top of my head is prerogative powers. Maybe not so fine in my opinion, but you find it in your material, so let's talk about it. And what prerogative powers are generally is, it really is just the residual or the remnant of imperial powers that the Queen, still holds and exercises in Canada till date, despite the independence of Canada. Do you appreciate that, or is it a mouthful? So of course, Canada used to be a colony. It is now fully an independent state, but still has some sort of honorary, recognition of the Queen, right? As the head of state, I believe, of Canada. And so in that capacity, the Queen still has some leftover powers, remnant powers, that she exercises through the Governor General. Now, it's important to understand that dynamic because whilst, we say that the Queen exercises those powers through the Governor General is essentially pretty much appointed by the Prime Minister. So if you ask me, or if you get asked in your question, an exam for your opinion or your thought, critique responsible governance or prerogative powers of the Office of the Governor General in Canada, if I were writing questions for the NCAs, that's a fine question. A lot of you will be thrown off for like 5 minutes and I'll be happy. Anyway, if you get such, invited to have such conversation, a fine way to critique it is to say that it essentially is still a power or a body of powers that is being exercised by the Parliament. Do you see that? Or by the executive, because the executive is subsumed. The head of the executive is the same Prime Minister who's the head of the Parliament. You see that? Because you say that it's a power that is exclusively reserved for the Queen, in honor of the Queen. But the Queen, of course, is not physically present in Canada, right? Her physical representative in Canada is the Governor General, and even though he's appointed by the Queen, that appointment is always based on the recommendation of the Prime Minister. So prerogative powers, the powers, fine example of prerogative powers in action or in exercise will be, for instance, declaration of war, the decision of who to award passports and citizenship to, especially if you're not, legitimately entitled to it, if you appreciate that, conferment of honors, issues that are not particularly that are a matter of discretion, if you like to put it that way. Do you see that they're largely discretionary? And there's conversation around whether they're reviewable by the courts. You see that are they subject to judicial review? Very fine question. I got that question when I wrote my exams in 2019. And the question was, I don't remember how it was drafted, but it pretty much pitched prerogative powers against parliamentary privilege and said, what are the powers of the court when it comes to the exercise of these two types of powers by, the parliament or the executive, the other arms of government. And what you need to appreciate with prerogative powers is that they're reviewable by the courts, right? Particularly where there is justiciable issues. And what are justiciable issues? Justiciable issues are, issues where rights and liabilities are already activated or triggered. Do you see that? So for instance, fine example that I always use is, whilst the decision of who to confer or who to grant a Canadian passport to, or who to award or grant Canadian citizenship to, especially if, you're not born here or whatever, is a discretionary issue. But there are a lot of immigration programs now that are policies of government. And then they say, do X, Y, Z, and you will be eligible for citizenship. Now, I have done X, Y, Z. You cannot just, as a matter of discretion, refuse. Do you see that? Because that is a justiciable issue. That is almost like a contract. I have moved positions. I have performed my own part of the obligation, right? You must come through. Do you see that? So you'd see, there's a whole full tribunal and board of immigration or whatever they're called, I don't remember, that reviews cases like that or reviews issues like that, even though the decision of who I want to award citizenship of my country to should be my prerogative, should be, a decision that I'm at will to make. But if you position it in a way that it triggers people's rights and liabilities, then we cannot leave you to just do as you please because you might abuse those powers. Hopefully you guys appreciate it. I don't want to dwell too much on it. Then we move to parliamentary privileges. Very important one. Very interesting as well. First thing you should note, like it sounds, parliamentary privileges, they're privileges or reserves of powers that are available to the parliament. Again, remember that I said that the governance of Canada, or the system of government in Canada, is heavily influenced by that of the UK. And so even though Canada diverges from the UK in that it has a supreme law, which the UK doesn't have, right? It has a supreme law, but the parliament is still maybe not supreme, but superior. Do you see that? And so these guys have certain privileges or certain reserves of powers that are exclusively available to them and are not reviewable by the courts because they have constitutional status. Do you see that? Now, what you also need to appreciate is that you cannot review the Constitution by the Constitution. Have I thrown you guys off? Does somebody want to say that to me in the way that you understand it? What do you get from me saying you cannot review the Constitution by the Constitution?
Hi, my name is Ginika.
Hi, Ginika.
Sorry for joining late. I was at work and I was trying to join from my phone, but right now I'm home now, so thankfully. That's so what you mean by you cannot review the Constitution is because the powers, the parliamentary privilege, which are powers given to the parliament, are said to be part of the Constitution. So you cannot now use the Constitution to review the Constitution.
Absolutely. Something along those lines is what I was looking to hear. Thank you, Ginika, to say that, not just parliamentary privileges, because really, if you look in the Constitution, there is no, express verbiage or language that provides for or confers, parliamentary privilege on the parliament. But before we zoom that into parliamentary privilege as a conversation, generally, there is no hierarchy when it comes to provisions of the Constitution. Once something is a provision of the Constitution, then it has constitutional status. It is even with every other part of the Constitution. Do you see that? So you cannot hold division of power against charter, or you cannot hold the amending procedures against charter or division of powers, because they all have even status. They are all the Constitution. Do you appreciate that? And so when we talk about parliamentary privileges, it's not expressly provided for anywhere, but it's very recognized, being pronounced upon by the courts over and over again. I'm giving you a bit of the history to say that it is informed by that influence, from the UK, to say that the parliament is so important, so germane. Remember again, off the top of my head or in my brain, the way that I have it shelved is that It was the decision of the parliament to even have a constitution. They could have decided, nope, we don't want a supreme law. We want to be fully patterned like the UK. But they decided that, you know, we will adopt the constitution. We will submit ourselves to a written body of laws, you know, or recognize written body of laws as supreme or superior to us. And so the court of the way that the court has dealt with that is to say that these guys are, you know, they actually really do have the powers. They have been quote unquote humble, you know, and introspective enough to let go of that power to a certain extent by adopting a constitution. So we shouldn't stifle them too tightly. Do you appreciate that? And so they have these privileges that are not reviewable by the court. Now, what is important to note with those privileges is that absolutely members of the parliament or members of the provincial legislatures can exercise these powers, but these powers must pass, the exercise of these powers must pass the test of necessity for them to maintain their status of being unreviewable by the courts. Was that a mouthful, or did you get it? They must pass the test. The exercise of parliamentary privileges must pass the test of necessity. And what's the test of necessity? The finest way that I'm able to explain it is to give you case laws. So I'll give you two case laws. There's I apologize, I'm very terrible with titles of cases. There's the Nova Scotia and New Brunswick and Nova Scotia Broadcasting Company, or maybe I'm mixing them up, but that case where, you know, the broadcasting company of one of the provinces wanted access into the floor of the house of the provincial legislature of the other province to record, you know, and capture what was going on, all the deliberations and all of that. And the provincial legislature had refused to say that, no, we're not going to allow you access for the purpose of recording us whilst deliberating. Do you see that? Now, as you study and you know you understand all the concepts deeper, you'd realize that there's the charter right of expression, where anybody is free to do, you know, to express themselves, so long as it meets the definition of expression. Now, recording members of the House is expressive in nature. The court has interpreted expression so broadly to be everything except violence. So that could have passed, you know, posed a very strong charter challenge to say that, what are you doing that we cannot see? Do you see that? But the provincial legislation of one of those other provinces, I don't remember, New Brunswick or Nova Scotia, whichever of them, refused that access and said, you cannot cover us. And that went to the courts, and the courts agreed with the provincial legislature to say that they have that power to refuse you because this is them in the direct line of discharging their duties as the parliament or as members of the parliament. So that is that test of necessity. If you're exercising, if a member of parliament is exercising parliamentary privilege in a way that is necessary or that is closely, intricately aligned to the discharge of their main obligation, to their main function, then it is not reviewable by the courts. You can do as you please. Contrast that case with Canada and Vade. I believe that's the case, Canada and Vade. When you go to study, look for the case of a member of parliament who fired his driver. That's the case I'm referring to. If I got the title wrong, I apologize. But the case I'm referring to is another case where a member of parliament had fired his driver, right? And the driver had sued that member of parliament for wrongful dismissal. Do you see that? And the case had gone up to the Supreme Court, and the Supreme Court had agreed to say that, I mean, at the position of the member of the parliament, because of course, one of the ways that parliamentary privilege is displayed is that you cannot sue individual members of parliament in their personal capacity. Do you see that? Whilst they are members of the parliament. And so the parliament had taken up the case, and the position of the parliament in defense of, you know, in their defense against the case or the argument of the driver was that we have parliamentary privileges. Our actions and decisions are not reviewable by the courts or by the courts using the Constitution. Do you see that? Or any other body of laws. And the court has disagreed to say, yes, we recognize parliamentary privileges. We have countlessly pronounced and upheld it, you know. However, in this particular instance, the exercise of parliamentary privilege fails the test of necessity because we're unable to appreciate how who you hire and fire as your driver affects your ability to discharge or is so necessary or germane to your discharge of your function as Hopefully you guys appreciate that and you see the reasoning of the court. Do you see that if it's intricately woven or too closely situated to your ability to discharge your function as, a member of parliament, then absolutely that's not reviewable by the court. You can exercise that privilege. But if it is far situated or detached, do you see that, then it is reviewable by the court. So that there, hopefully you're able to do a little bit of contrasting and comparing of prerogative powers and parliamentary privileges, and hopefully as well you understand finer what parliamentary privileges are, given the review of those two cases. But those are two cases that you should look into when you're studying parliamentary privileges. Okay. I don't know if I'm missing out anyone.
I remember. Yes. I remember the two cases. The first case is Nova Scotia against New Brunswick Broadcasting Corporation. Then the second case of the driver, I remember the case, whether it's Fraser, but I cannot remember the facts of that case, if it was the Parliament of Canada that employed the drivers, among the drivers allocated to parliamentarians, or the parliamentarian employed the driver in a private capacity.
The conversation there was that it was a member of parliament who had, I don't know that the facts included in what capacity, or I don't recollect in what capacity the driver was employed. But, with our understanding of parliamentary privilege and the holding of the court, it really won't matter whether that driver was employed by the member of parliament in his personal capacity or in his official capacity as a member of parliament, because the conversation is the service of a driver is not so closely situated to your ability to, except you're saying you're unable to get to work because you don't have a driver. Do you see that? It's not that closely situated to or necessary to your ability to discharge your function as a member of parliament. Do you see that? But absolutely, maybe you should look closer into that. Everybody look closely into that case to see if the court, good issue to highlight one, if the court considered that issue of whether it was in his personal or in his official capacity, because what you realize eventually is that case was Canada versus Vade, so that the parliament had taken on the case. The member of parliament wasn't being sued in his personal capacity. The parliament had taken it on. Do you see that? Because they, of course, again, have parliamentary privileges. They are not answerable to the court in their personal capacity whilst they're members of parliament, just like what you have in a lot of, the drama that's going on with Trump now because he's no longer the president in the US. Do you see that? But yeah, good point to raise if you're inclined to go back to look closer at that case. But you would find that it didn't really make much of a difference. Do you see that? Okay, I believe that we've touched on all the sources. If anybody's looking at your materials and there's a source I haven't touched on, okay, no, then you have conventions and usages and rules and laws, and all that you need to pay attention to is there. Of course, look at it deeper, but all that is going on there is that, again, because Canada is such a polite and, if you ask me, gentlemanly society, you'd have quote unquote gentlemanly agreements or just practices that, that are like the bedrock for administering certain issues, right? Fine example would be things like the oldest judge or justice of the Supreme Court is the one that is appointed to become the head of the Supreme Court, or just certain unwritten rules that everybody's quietly aware of and nobody has particularly substantially departed from. Now, they are kind of like in a graduated formation. So you have conventions, I believe it's usages that can be diverted from. So we've had instances where it really wasn't the oldest member of the Supreme Court that was appointed to be the head of the Supreme Court, but there is still that calm understanding that ideally or typically it should be that way, right? But if there are other issues or factors that are considered, then that can be deviated from. Then you have conventions that are hardly ever deviated from. Okay, fine example would be the appointment of the Governor General, right? It's not written anywhere, but as a matter of practice, as a matter of convention, yes, the Queen appoints, but it is always on the recommendation of the Prime Minister. Do you see that? She's never not appointed who the Prime Minister recommended. Do you see that? And then you also see conversations around how those can now be formalized and captured in a written document, whether as a policy, which now makes it more defined, or as a law, which now makes it justiciable, reviewable by the courts. Do you see that? Because take note, those on written or unspoken rules are not justiciable. The courts can recognize them to say, we know that this is what you should do. We don't understand why you're, deviating from it now, but the courts are unable to enforce them, to compel, maybe the prime minister to say, or the queen to say, oh, queen, we compel you, you must appoint who the PM recommends. Do you see that? But if they are adopted as laws or adopted as policies or enacted as laws, then it changes a bit. Do you see that? Because they can now be justiciable and you can now have a conversation around it. Okay, I think that's it. We've spent more than half of our time together on just chapter 1, but there really is, a bit to, and a lot of tutors skip over it, but I'm unable to. Again, like I said to you, I'm not a tutor who breaks constitutional institute. And the reason for that is because my exam, everybody had said to me, you just need to study division of powers and charter and you're good. But I walked into my exam hall and I had one 40 marks question that was, I think, a summation of charter and division of powers, 40 marks, and then 10 6-mark short answer questions that were scattered everywhere across the syllabus. And they were just 6-mark questions. So if you didn't know it, you didn't know it. Do you see that? So imagine that question I said to you, something along parliamentary privilege and prerogative powers, which is reviewable. I know a lot of people who have written and passed the exams and don't know those things. Do you see that? But because of the way that my exam was presented, I'm very quick to tell everybody, you might get away with it. You might get away with studying just charter and division of powers, but you might just have my type of exams. And I've always also said, especially with the way that the NCA sets the questions, in the last 3-4 diets, they're moving away very, very, moving away from that old pattern that has now become very predictable. You can have all sorts of questions. Aboriginal rights is now very big. You must have an Aboriginal question, even if it's just 10, 15 marks. Do you see that? And you now have all those random, you now have questions that are asking you for your appreciation of the policy or the reasoning for the decision of the court, to say, the court in, for instance, I think one very good culprit is usually the Whitler case, Canada versus Whitler, when you're talking equality rights. Now they're not asking you to apply the decision of the court to a case. They're asking you to critique the reasoning of the court. Why did the court come up with this decision? Do you agree with it? Does it make sense? You can't answer a question like that on one-liners or just knowing what the decision of the court was. You need to look a bit closer. First of all, you need to appreciate the facts, and you need to be able to also appreciate the journey of the court's mind before it arrived at where it arrived at. All right, okay, let's go real quickly to chapter 2. I typically don't spend a lot of time at chapter 2. I think that chapter 2 is the easiest thing on this syllabus. All you need to do is pick up your Constitution Act 1982 and start your reading from, I believe, section 38, typically, and then go all the way to 44. Just read the Constitution itself and you'll be good. There's nothing tricky or overlapping about the amending procedures, right? Again, as some form of history, remember that the 1867 Constitution Act, one of the critiques or one of the failings of that Constitution Act was that it didn't provide for amending procedures, and that was so important to the autonomy or the independence of Canada because it meant that Canada still had to consult with the UK. Now the 1982 Constitution comes and introduces amending procedures and says, okay, to amend your constitution, this is what you need to do, or these are the procedures that you need to adopt. For issues like XYZ, you have to use a general amending procedure, which is also called the 750 rule, which means that you not only need at least 50% of the population, you also need those 50% to be distributed across 7 of the 10 provinces. And the reason for that is that we don't want, for instance, Quebec and Ontario, who are comfortably able to pull in 50% or just a little shy, to always pitch together, to the detriment of the other provinces. So the drafters of the Constitution had said, we recognize that, the provinces are not evenly populated. Do you see that? And so to forestall or present any malicious power play, do you see that it's not enough that you have 50% votes in favor of your proposed amendments, you also need to ensure that that 50% is decently widespread across the provinces. That essentially is the 750 rule. Then you also have a couple of other issues listed that, the Constitution has provided for that must be amended using the unanimity procedure. Typically, you find that those are the, more sensitive, more weighty issues. Everybody must, at all 100%, all 10 or how many provinces do we have, must be aligned. Then you have the some but not all. If it's not your business, you don't have to vote. If it doesn't directly impact you, you don't have to vote. Fine example of that would be boundaries. Ontario and Quebec are fighting over boundaries and want to amend procedure in that regard. It has absolutely, Alberta could not be bothered. So we don't need you to vote. So that's essentially the some but not all. Do you see that? Or Manitoba is struggling to amend the constitution in relation to its language obligations, its obligation to discharge governmental functions in both English and French. Has nothing to do with BC, for instance. Has nothing to do with Alberta. They don't have similar obligations to discharge governmental functions in English and French. Then you have the Parliament alone. Amending procedure. You also see the issues that are listed there. And I usually advise, if you can, maybe print out your 38 and 40. If you come in the class, we will read out the provisions of those sections word for word. I'd have somebody, or we'll rotate amongst the people on the call. We read it out, we speak to it, we explain there's the proportional representation issue, and a few other opting out, compensation, proclamation that we should go into, but I won't break a sweat over it. Just read through the Constitution, in plain English, and you should be fine. But if you come on the intensive classes, we will read through it, we'll have a quick chat over it. We'll review a case that I find very interesting, and I'm inclined to give you now, even though I don't know why that should, or why you should now come and pay for my class if I give you that case. But it's an interesting case. I think you should look at it. A lot of people don't talk about it on their amending procedures. Again, if I was an NC examiner, I would ask that question. And if you ask me, I think it's even one of the sample questions or the questions on the website. One of the questions on the website or the sample question on the website has to do with amending procedures. And in my opinion, you absolutely will get that question wrong if you haven't looked at that case. And the case, I believe, is Campbell and Canada. Again, I'm bad with titles of cases, but I believe that's what that case is, Campbell and Canada. You can write it down and look into it. But yes, if you come on intensive classes, those are some of the things we would review. And then we move real quickly to chapter 3. I believe chapter 3 is federalism. Please correct me if I'm wrong. Federalism, and as well, am I right?
Yes.
Right, okay, and then federalism as well, there's not a lot to say, in relation to federalism, especially, given all that we've said, you need to appreciate that Canada runs a federal system of government. When you go to study your materials, you see conversations along the lines of trying to compare federalism with different other systems of government. Read it, but I don't think you should break a sweat over it. And then the conversation gets a bit more important in that it starts to give you reasons why Canada adopted federalism or why federalism works for Canada. And like I said, you're trying to avoid concentration of powers. You're trying to ensure you're trying to ensure that government has a finer reach, optimum reach. And then in the peculiar instance of Canada, you find that with Canada, like a lot of colonies, it's just a marriage between territories and groups of people that really do not have a lot in common. Do you appreciate that? They really don't have a lot in common, or even if they have a lot in common, they have, peculiar goals or peculiar issues that they consider important to them that are not shared across board. Do you see that? So, and if you ask me, it's one of the issues that Canada still has till date with Quebec. Quebec is always fighting tooth and nail. It just wants to get out of this British marriage, right? And a lot of us that come from countries that have been colonized would appreciate this conversation. You see that? And so some school of thought have advanced an argument to say federalism works good for Canada. Federalism in the division of power, there's a federal government, there's a provincial government, in that the diversity, right, and the differences that all these territories have can still be honored and maintained, at least at the provincial level. Do you appreciate that? Even though there is you know, there is a unifying port. Do you see that? And a couple of other justifications for federalism in Canada. That essentially is the conversation under Chapter 3. Please read it, you know, at least once. Have a quick once over. And then we get into Chapter 4, which is where the meat of the conversation is. I'll be honest with you, and maybe I should invite your thoughts. Would you have me give you brief overviews of each topic, or do you want me to do a bit more detail and drilling? What that would do is that if we do a brief overview, then we'll aim to touch on all the topics. But if we drill in, then most likely, I certainly need more than 30 minutes we have left to talk on just Chapter 4. So which do you think is better or more advantageous for you? Okay, I'll go with my... Okay.
Give us the details. I think you should give us the details.
Give us the details of Chapter 4.
Yeah.
Okay.
Let's hear what others have to say.
Does it work for everybody? I take your silence as consent.
I don't consent. I'm going to be the devil's advocate. I think a helicopter view of the entire syllabus will be better for us at this point. I honestly think so. I don't know, but I'll defer to the group. I'm just one member of the group this morning.
Because charter and the division of powers are the most bulky, so even if you want to do a good job, you cannot even use one full class of 3 hours just to treat charter or division of powers.
Okay, let's run through the chapters, because ideally that's what this should be. It's just I find that
It's introductory.
A bit more detail is helpful. It makes you itchy to go and pick up your materials to start to study. At least you know what you're studying with the first few chapters, and hopefully you're able to gather enough steam to go on. But let's see what we're able to do with just, you know, a brief 2 lines on each chapter. I'm going to need your help. I'm going to need somebody to give me the chapters as we go, if we're going real quickly. Hopefully that will chase you as well into my classes. Okay, so Chapter 4, I believe, is judicial interpretation and
judicial review and principles of interpretation.
Oh, I'm sorry. Judicial review and principles of interpretation. Judicial review, overview, like we agreed. We're not getting into detail. Overview, like it sounds, judicial review is that with the situation that Canada has found itself in, I apologize, I call it a situation, right? With federalism, in that powers are divided, right? Means invariably that there will be conflicts, there will be disputes, there will be overlaps, there will be incursions that are not welcome, you know? So the parliament will pass a law and like 5 provinces will jump up and say, hey, you stole our show. That was not your business. That was not your, you know, jurisdiction to delve into. There will be conflict. Even with charter, you know, what the essence of the charter is that Seun can stand up tomorrow and walk into the court and say, the government of Alberta is stressing me and they're trampling on my charter rights. Do you see that anybody can do that, right? And so there will be issues to be resolved. There will be disputes to be addressed. Do you see that on the one hand? On the other hand is that typically, I mean, with human relations and the acknowledgement of the existence and operation of one supreme bodies of laws, that is a measuring stick for other laws. Somebody has to do measuring. Do you appreciate that? Somebody has to say, okay, this is the standard. This is what you have brought. What you came with falls short of the standard, or what you came with is fine, you know, in accordance with the standard. So somebody needs to do that, all that reconciliation, dispute resolution, measuring and standard review, and all of that in one summation is what is referred to as judicial review. Again, judicial because, of course, it's the court who does all that dispute resolution, measuring, interpretation, you know. So there's a new law. Alberta, I'm sorry, I'm in Alberta, and I have newfound love for Alberta. Alberta was my first love. I walked away from her. And now that I'm back, you can imagine how strong the love is, right? So I keep using Alberta. Okay, let's use BC. So BC has passed a law, right? ASTA has decided, I don't know if you're in BC, ASTA, I apologize, but let's assume you're in BC. You've decided that this law is so vexatious to my rights as a resident of BC. I'm going straight to the courts to challenge this law. Somebody needs to look at that law to interpret it and understand what that law is first, right? And then also interpret the measuring standard, which is the Constitution, to say, when the Constitution says, for instance, marriage, this is what the Constitution means. This is how we choose to interpret marriage, right? Now, you now marry both interpretations, your interpretation of the Constitution and your interpretation of these BC laws for the purpose of determining consistency. Do you see that? And that right there is judicial review. And hopefully you're also able to appreciate why principles of interpretation goes hand in hand with judicial review, because there is almost no review without an... You guys have slept off on me. There's almost no review without
interpretation.
Absolutely. Somebody needs to open up. The Constitution is constantly being interpreted. The old interpretations are constantly being revised, which is what you see in the Greenhouse 2020 case, right? Trade and commerce used to mean this. The court interpreted it to mean this. But in the light of this case, we're going to slightly modify that. Do you see that constantly? Progressively, right? So also laws of, particularly laws with federal, division of powers. So another quick hack is when you talk laws, typically you're talking division of powers. When what you're reviewing is a legislation, then it has to be division of powers in that, did you have the power or the jurisdiction or the competence to enact this law? When you talk judicial review on charter grounds, it usually is a mix of both laws and actions. Candidates are usually tipped off on that conversation, but that's a fine way to understand it. Usually with laws, you cannot review government actions on that division of powers, because remember the division of powers divides legislative powers. Now, legislative powers are needed to enact legislations. A governmental officer empowered by legislation can now act out in a way that offends your rights. So that what you're doing is you're challenging both that legislation that empowered or authorized that governmental actor, as well as that governmental actor's action on that charter in a way that, because it has infringed on your right. But typically, if all you're saying is this law is bad law, I don't want to be held, I don't want to have to comply with this law, then typically you are you're looking at 91 and 92, because take note, we're out of time. I'd have invited somebody to read section 24. You cannot have a charter review if you haven't suffered a damage. Does that make sense to you? You cannot have a charter review if you haven't suffered a damage. If you're right, there are no prospective charter reviews to say the way I'm looking at this law is going to breach my rights. No, it cannot be in advance. You must have suffered a breach for you to have locus to bring an action for judicial review on charter grounds. Hopefully that is that makes sense to you guys. So you see how judicial review and the principle of interpretation go hand in hand, because for the court to judicially review a legislation for the purpose of confirming that it is consistent with its interpretation of the Constitution, then there is a lot of interpretation going on there, and the court needs to have established principles that assist or aids it in its interpretation exercise. It's important that those principles are clear to achieve consistency and uniformity, so the court is not being arbitrary. Today we interpret this way, tomorrow we interpret that way. And so that is why you have principles of interpretation going hand in hand with. Because if we understand the principles that assist the court in interpreting, then we can follow along with the court's review process, or with the court's reasoning process to say, okay, this is usually interpreted that way, and the court has adopted that principle, which is why it landed, at this conclusion. And for that reason, it is upholding this law, or for that reason, it is striking out this law. Hopefully you understand that, and hopefully that works in terms of a high-level overview. So, of course, in your detailed study, you now have to open up what those principles are. Nothing. It's if you ask me, just high school government. Of course, we've all studied principles of interpretation, where you have the progressive principle, the liberal principle, things along those lines are what you'll be looking at, and then how those feed into judicial review. For the purpose of judicial review on federal grounds, you have more aligned, more specific principles that the court adopts or has established to assist it in reviewing for consistency with sections 91 and 92. And of those principles would be the paramountcy, federal paramountcy principle, interjurisdictional doctrine, and the pith and substance doctrine. Now, a lot of candidates study those doctrines as detached conversations, but I find that if you view them as doctrines that assist the court in interpretation, right, then it feeds better and gives you better context to say that, okay, because the interjurisdictional principle or doctrine says, yes, you have the right to enact within this scope, and you can enact a bit outside of the scope of your jurisdiction so long as it is incidental. However, that extra incursion that, for instance, the doctrine of the pith and substance doctrine allows you, right, in the case of incidental issues, will only go this far. It will only go as far as where it doesn't impair an essential operation of. Do you appreciate that? I think I've thrown you off a bit. But in terms of a high-level overview, those are some of the things that you should be looking out for when you start a study. So when you start to study, when you go under chapter 4, you start to see, the pith and substance doctrine. Look at that as a principle of interpretation, as a style of interpretation that the court has established that assists it in interpreting impugned legislations for the purpose of determining what they are in relation to. Because remember when Onyinye read 91 and 92 to us, what it said is the parliament will legislate in relation to XYZ subject matters. The province will have the powers to legislate in relation to these matters that are listed here under. So when a legislation comes, the court needs to interpret, open up that legislation, completely tear it apart, for the purpose of determining what it is in fact in relation to. Do we understand that? Right? I can't even ask you if you have questions, because definitely you have questions. But remember, we agreed to do brief overviews. So let's go to chapter 5. What's chapter 5, please?
Property and civil rights.
Absolutely. And so now on that, thank you, Onyinye. So after we've reviewed judicial review and the principles that assist the court to interpret both the Constitution and impugned legislations, then we're now invited to review some of these subject matters. Remember, we said legislations are in relation to subject matters, like when you read out, the province legislative assemblies of provinces are exclusively authorized to legislate in relation to this subject matters listed herein under or hereinafter. Now the NCA invites us to understudy more closely some of these subject matters listed hereinafter. Do you see that, right? So, and I mean, of the ones that usually are in the NCA syllabus, just property and civil right is competent to the province. That alone should tell you, should be instructive or indicative of how expansive that head of power is. Do you see that? That property and civil right head of power that belongs to the province. So it has only, as it has been interpreted by the court. Again, remember, all the Constitution does is it lists out these heads of powers, these clauses or phrases, if you like: marriage and matrimony, property and civil rights, mining and exploration. Somebody, the court, the judiciary, had to do the hard work and keeps doing the hard work of unpacking it. What exactly is entailed in property and civil right? What is entailed in trade and commerce? What does criminal law mean? What does POGG include? What does it not include? That is interpretation going on there. Interpretation, in this case, of the Constitution, on the one hand. And then you also see the court interpreting, impugned legislations. Have I thrown you off? Is it clumsy? Does it make sense to you guys? Right. Yeah. So the first one that the NCA invites us to understudy is property and civil right, because we need to know what property and civil right includes for us to be able to, assign a legislation underneath it after interpreting that legislation. And of the many things that the judiciary has interpreted as property and civil right, you have insurance. The court has said that insurance is competent to the provinces on the property and civil right. Brief overview. Let me not get into the details of what the court has expressly declared as being, being classified or categorized under property and civil rights is that, as it sounds, property and civil rights, I mean, quickly, civil right not necessarily meaning civil liberties in terms of human rights or charter rights, right? Civil rights in terms of civil law, like civil relations, civil bodies of laws, laws of contract, laws of torts, what other civil, bodies, and civil also matrimonial. Do you see that things that are not particularly, criminal? That's a fine way to explain civil. So civil laws, not in terms of civil rights and liberties, like fundamental human rights, also not in terms of common law versus civil law, but civil law just in terms of all bodies of laws that are not criminal related, that are not criminal. So you have banking, banking might not be a fine example because banking specifically is assigned to the parliament, right? Given the nature of banking, you're holding people's monies, it's a bit sensitive. So the Constitution specifically assigns that to the parliament. But I'm trying to give you, assist you to understand what civil rights under property and civil right means. So contracts, torts, fine example, thank you, on matrimonial issues. That again is dicey because that is kind of like split between the parliament and the province. I believe maybe marriage and solemnization of marriage is competent to the federal or the province, one of them, but you have to be careful because that's not one of the heads of powers that the NCA has invited us to review deeply. I think I studied it for my bar exams, but yeah, the federal government has some jurisdiction when it comes to matrimonial issues, whilst the province also, has. But yeah, civil issues like that, civil issues between the citizens, do you see that are competent to the province? And that's, that's a loose way of explaining to you what property and civil rights include. And of course, property, not necessarily landed or immovable property, but also movable property and your interest in those properties. You see that essentially is what the court has interpreted as being able to be classified under property and civil rights. So what that means is if a province enacts a law, for instance, in relation to contracts, to say, going forward in Alberta, if Judith says, anybody who smiles at me will get slapped as a matter of contract, and all of us on this call, execute such a contract, then Judith must slap. Do you see that is competent? That is the business of the province. If Alberta wakes up tomorrow and says, it's fine, transfer of interest in immovable property, which as before now must always be by way of a written instrument, no longer has to be by way of written instrument. Alberta is able to do that. If BC says electronic signature is a fine example. You see, with the pandemic, you see a lot of provinces amending their, whatever that body of law is, just to admit, and allow for electronic signatures. To say, we see the pandemic, we see everybody stuck at home. Going forward, we amend our maybe Property Conveyancing Act or, Consumer Protection Act or whatever, commercial specific issues it is, to allow for electronic signatures. Do you see that? So those are some of the things that the court has contemplated as being able to be properly classified or categorized under property and civil right. Okay, chapter 6, because if you leave me, I can give you 2 hours on property and civil right.
Trade and commerce.
Trade and commerce is, again, another one of the subject matters or heads of powers, like I said, that when you read that XYZ shall be competent to enact in relation to the following subject matter. So if you go under 92, you will see property and civil rights. I believe it's 92:13. You have to forgive me. I do horribly with memorizing. Okay. Then if you go under 91, you would see trade and commerce. I don't know which of the subsections, but one of those subsections you will see trade and commerce, and that tells you that trade and commerce, because it is under 91, is competent to the Parliament. Thank you, right? And trade and commerce, like it sounds, there's a bit of an interesting conversation to be had in contrasting and comparing trade and commerce and property and civil rights, because I mean, just off the top of your heads, even if you haven't studied extensively, you'd see with my explanation of trade and property and civil rights, you see that there's a lot of commercial issues being contemplated there. I talked about business, contracts, contractual relationships, talked about electronic signatures. Those are very contractual, very commercial, business-like. And then here you have the Constitution under 91, again, providing for and assigning a head of power called Trade and Commerce to the Parliament. So there is a very decent level of overlap between the Parliament, Trade and Commerce head of power. Somebody needs to mute their mic. Godwin. It's fine then. So you see that going, what the Trade and Commerce power essentially is that the Parliament has the powers or the competence to regulate commercial activities and activities in relation to trade within Canada, particularly as like at the federal level. Do you see that? So with property and civil rights.
Sorry, Seun, we missed you at some point.
Oh, I'm so sorry.
Yeah.
So did you get anything on Trade and Commerce?
No.
Can you hear me now?
No. Yes.
Okay, I'll just take Trade and Commerce again. So what I was saying is that hopefully with the appreciation that you have on property and civil rights, you can anticipate that there's a lot of commerce and trading and business relations going on there with the way that we've interpreted property and civil rights, property, civil contracts, torts, you see. But with trade and commerce, a fine way to distinguish it is that this is trade and commercial activities at a federal level or at an interprovincial level. So if it's trade and commerce within Alberta, then it's Alberta's business. But if it's such that, it's trade between Alberta and Quebec, for instance, then there might be the need for some big brother type incursion. Do you see that, right? To regulate it. Or if it's trade and commerce between Canada and Mexico, right? I can't think of any real life example of something that maybe Canada exports to Mexico or Mexico, did you see that? But if it's something, I mean, Canada and the US is fantastic because they're all sorts of national trade agreements and, reciprocal agreements. At that level, definitely Alberta is not the one who's going to be calling the shots. Or Ontario or Quebec, it has to be the federal government in a representative capacity for all the provinces. High level overview, let that guide you. Trade and commerce and property rights are a bit confusing. In fact, there are court cases that have contributed to the confusion along, those lines of the jurisprudence, where the court in one breath says interprovincial trade should be regulated by provinces, and in another breath it says interprovincial trade should be under trade and commerce. But the general framework, which if you deeply understand federalism, right, makes sense, is if it's within a province, right, I believe it's 9216. Anybody able to read 9216 to us real quickly? 9216 talks about, matters of a general local nature. If it's not 16, then maybe it's 15. Do you guys still have your 1867 Constitution Act, Section 92, sub 16, I believe? Anybody? If not, it's fine. I'll just keep going. But yeah, if it's intra-provincial, then it most likely is, or most definitely is, competent to the province under property and civil rights. But once you have, the introduction of another province or another nation, a foreign, you see that entity, then definitely you need to, bank on the federal government's trade and commerce power. Another fine way that the trade and commerce power has been exercised and approved of by the court is, commercial consents that affect the entire nation as a whole, not a particular industry, not a particular product, but just the nation as a whole. And the finest and only example that we have till date, okay, maybe not only because of the new greenhouse case, because the greenhouse case was something along those lines as well, with regulating carbon emissions, right? But before the greenhouse case was, finally decided on by the Supreme Court, the only other example of case law that we had in the jurisprudence was the General Motors Leasing Company case, right? Where the Parliament had enacted what is now called the Competitions Act, just encouraging competition in the entire country. So it wasn't a legislation that was specific to, for instance, the manufacturing industry or the healthcare. It was just saying, going forward in Canada, with all our commercial concerns, we want to encourage competition. No collusion between competitors. Let the market have a free play. Do you see that? So yes, that's another fine way of looking at the Parliament's Trade and Commerce. Okay, high level overview. We move. 7.
POGG.
POGG is interesting, and there's a lot to be said. It can be confusing, so I'd advise that you take your time when you're studying POGG. Not to scare you, it's very interesting. If you get into the rhythm, you will follow along with the reasoning of the courts. You'd see why the court held whatever it held, right? But it's a mouthful. The cases, definitely for POGG, please review your cases. I mean, as well for principles of interpretation, when you start to review, when you go back to the Pith and Substance Doctrine, the interjurisdictional immunity doctrine, the federal paramountcy doctrine, please review those cases. Those are not cases that you want to have one-liners on. You want to have the facts and you want to understand why the court held what it held, so that you can appreciate the court applying the principles, so that when it is just you and yourself in the exam hall, being Justice Godwin, for instance, you are not stranded, because that's essentially what the NCA exams are. We are all justices in the NCA exam hall, applying established principles of interpretation to simulated legislations. Do you see that? So absolutely read the case laws on those. POGG, like Oyeye read, was provided for by the opening words of 91. It says, the Queen, through the Senate and the House of Commons, shall have the powers or something to enact legislations that are in relation to the peace, order, and good governance of Canada. That's where you get the acronym from. Peace, P, order, O, G, good governance, right? Now, as it sounds, it is very amoebic. It doesn't particularly take on one shape, because again, kind of like the property and civil right, it has been argued by some jurists, Hoggs included, to be a residual type of power. A residual type of power. So where it has not been expressly provided for, and we can argue that it's in relation to something that concerns the entire nation, then a fine place to assign it will be peace, order, and good governance. Do you see that? Right? But there's a whole mouthful to be said. Have it at the back of your mind that it is residual, in that it is not expressly, kind of like what you would have with, for instance, banking. Banking is pretty clear. Anything that has to do with banks, is content of the Parliament. Trade and commerce as well is quite defined if it has to do with trade and commerce. But with peace, order, and good governance, it can get a bit out of hand, right? And it also, in my opinion, alongside criminal law, is one of the most frequently used head of powers by the Parliament. Even this Greenhouse 2021 case we keep referring to was under POGG. So it's an interesting head of power, but it can get dicey. Let me market my intensive classes. If you come on the intensive classes, we'll have a whole, we'll have a lot of time to open that up. Look at the 3 branches, because there are 3 branches going on there, particularly the national consent branch, which has a test, the distinct test that you need to understand. And then we'll open all of that up, and then you should be able to identify it wherever you see it. If you have been following the news, a lot of the legislations that were passed during the pandemic, right, were POGG type legislations, just to ensure peace, order. I mean, some of them were emergency, which is also a branch of, actually, so it's not even, it's just a branch of POGG. So there's an emergency, the integrity of Canada, or the safety of Canada as a country is in peril. Do you see that? Then you trigger POGG. Do you see that? It's an issue that concerns the entire nation. The provinces are twiddling their fingers, or the provinces, even if they're not twiddling their fingers, are really not able to efficiently address this issue in all its ramifications, then you trigger POGG. Do you see that? And conversations along those lines. Okay, chapter 8.
Criminal law.
Criminal law is, as it sounds, remember I tried to distinguish in explaining property and civil rights to say once it's not criminal, it's civil. So in that basest way of explaining it, once it's not civil, it's criminal. So once you start to talk about, the substance of criminal law, substantive criminal law, what is criminalized, what is not criminalized, who assigns the sentences and the sanctions, then that is out of bound to the provinces. If you study closer, you see that administration of justice in criminal litigation is competent to the provinces, but the substance, which is pretty much procedural, administration of justice, you see that, but the substance of what does the criminal code say, what is a criminal offense, what happens to you when you have been found guilty of a criminal offense, is only competent to the parliament. Do you appreciate that? Now, in reviewing criminal law as a head of power, you cannot review criminal law as a head of power without reviewing cases like the margin reference, because the margin reference gives you the ingredients that helps you to identify what is criminal. Because if you go to 9215, I believe, you'd see that as much as we've said that criminal law is completely out of bounds to provinces, 9215 allows provinces to enact laws that have sanctions. Can somebody read 9215 to us?
I'm there.
15, please. Is it 15 or 16?
It's 15.
15, thank you.
And it says the imposition of punishment by fine, penalty, or imprisonment for enforcing any law of the province made in relation to any matter coming within any of the classes of subjects enumerated in this section.
So hopefully you heard that, you heard what we hear it, or you're looking at it as well. So you see that, and that has been 1516 has been subsumed under property and civil rights. So you'd see that a province in exercising its property and civil rights can send you to jail. Some tutors teach to say that, oh, if it's just a 6-month term, then it's not criminal. Not necessarily, right? Or if the province is assigning a 5-year jail term. We all read the Constitution. The Constitution says imposition of fine, sanctions, and imprisonment. But and it's quite confusing because that's clearly an overlap, because when you read margin reference, you see that to be able to identify a subject matter that is in relation to criminal law, you have the 3 Ps. That's what happened in margin reference. I don't want to get into the details with you because we're almost out of time and we're not even halfway through the chapters. The 3 Ps, penalty, prohibition, and what's the third one? Criminal law purpose. So there must be a valid criminal law purpose. And what that just means is that at the sound of it must sound like something criminal in nature. Do you see that? It must maybe be in relation to the peace and order of the community, or safety, or protection of bodily harm, or bodily integrity, things along those lines. There must be that element where, as a community, as a society, we all agree that this is very criminal in nature, right? And then there must be a prohibition. You shall not do that. Anybody who does that, then penalty. Do you see that? But there are a lot of provincial laws that also present the 3 Ps. Do you see that? Fine example usually is traffic offenses, but that's like the basest, the dumbest, right? Traffic offenses, Alberta has a right to, say that this road is a provincial road. In fact, even municipalities, Calgary can say this is an 80 kilometers per hour road. Thou shalt not drive above the speed limit. If you drive above the speed limit, XYZ will happen to you. It has the 3 Ps. There's the valid criminal purpose because it's protection of life and property, safety. It has the prohibition, you shall not go above the speed limit, and it has a penalty. So it's confusing. There's an overlap there, and you must be trained to be able to identify which is still a valid provincial law, meaning that it is just the province exercising its provincial property and civil rights, particularly as provided for under 9215, that allows it to impose sanctions that might make it appear to be a criminal law, right? Or actual criminal laws that are an incursion into the parliament's jurisdiction. Do you appreciate that? So again, quick overview for criminal law. Please review margin reference. Please review re-firearms reference. Very important. Re-firearms reference. If you ask me, I think those are the two cases that I will really emphasize. I don't know. I don't remember what cases are listed under the syllabus, but absolutely read the cases under the syllabus. But those two are very, very important to your understanding of the criminal law head of power. Okay, next. And of course, while studying criminal law and property and civil rights, pay attention to section 92 sub 15. 92 sub 15 that allows provinces to enact legislations that include imposition of criminal sanctions, supposedly, so long as the main matter, the core of the legislation is in fact competent to the province. Do you see that? Okay, next. Next should be
ancillary powers.
Ancillary powers. I mean, this also, it's an introduction to the syllabus, but it's always been a conversation that I've always had with my clients, though briefly in passing, to say that an ancillary powers, where you should have ancillary powers. I mean, let me take a look at the syllabus myself one more time before I judge the NCA. Okay, fantastic. Okay. I was going to say that you should be understudying ancillary powers somewhere along the lines of interjurisdictional immunity and paramountcy, but that, and the doctrine of the Peace and Substance doctrine, but absolutely those come right immediately underneath. And what ancillary powers is, real briefly, because you guys want a brief overview, is that, remember that when you read 91 and 92, I asked you guys if you were able to appreciate the exhaustiveness of the division of legislative powers, but more importantly, the exclusiveness. In fact, that word was used in the Constitution. It says exclusively assigned to the Parliament or exclusively assigned to the province. And so ancillary, and then, I mean, I don't want to juggle your brains up, but I have to touch a bit on the Peace and Substance doctrine, for instance. And I'll give you what that says in 2 lines. I'll try to. I used to have a different bottle to explain it, but my bottle is new. So my old bottle used to have a plastic cap, a black plastic cap. And what the Peace and Substance doctrine says is that a legislation will not be invalidated for being inconsistent with the Constitution because it touches on issues or subject matter that are outside of the area of competence of the enacting body if that incursion is merely incidental. Even I think that is a lot. So I'll give you 2 seconds to process it, then I'll probably say it again if you want me to say it again. Right? Remember that we said that there's been an exclusive division. Parliament play in your field, provinces play in your field. Now, when you started study chapter 4 particularly, and the heads of powers and the topics that follow underneath, you would see that, of course, just because of the sheer fact that it is human relations we're talking about here, it's difficult to have a very straight-jacketed, strict compartmentalization going on there. Fine example, traffic laws. You acknowledge that there are traffic laws that are provincial laws and so not criminal, but there are traffic laws that are criminal laws. If you kill somebody on the road, that is full murder. But it has traffic because it happened on the road. You see that most likely you had breached one traffic law because you were maybe driving under influence, and there's a traffic law that says don't drive under influence, or you were driving past the speed limit. So there's a traffic part of it, but it has also now graduated into a criminal. Do you see that conversation? So you'd see that there's usually an overlap. I don't like to use the word overlap. I think it's just a commingling. Do you see that? It's just an interaction. It's not an overlap in that it is rude. I see your boundary and I'm just coming on top of your boundary. It's just an almost unavoidable commingling because we're dealing with human relations here. Do you see that? And so what the courts have said in determining the subject matter, I apologize, I do badly with brief overviews. I get so passionate, and it's almost time. Okay, let me leave it at brief overview and just say that ancillary powers, when you're studying the Pith and Substance Doctrine, Interjurisdictional Immunity Doctrine, Paramountcy Doctrine, pay attention to your understanding of what we have defined as federalism, to say that, oh, it's a clear division. And ask yourself, you know, is a clear division even possible world over, even in the US? It's not possible, like a complete, clear, bright line. It's not possible. And the way that different systems of government have been able to accommodate that commingling and blurry areas is either the provision of ancillary powers to say that if this is your area of competence, and you know, somewhere here will be an incursion, but it's ancillary to you being able to perform your duties, then it's okay, you can take that on as well. Do you see that? But, and that's what you have in the US, for instance. But in Canada, the Supreme Court has said it makes no sense, because whilst we appreciate that there will be blurry areas, there will be overlaps, we also need to preserve exclusivity. And so it's just semantics, if you ask me. You know, and so what the courts in Canada have chosen to adopt is the rational connection test for incidental incursions. You can write it down if it doesn't make a lot of sense to you now. When you start to study, it will open up better. Or if you come to my intensive classes, then we open it up better. Right, when you start studying, the rational connection test to say that this is my bottle. The Pith and Substance Doctrine says, or division of power says, silver metal, subject matter, head of power, is competent to the province. Whereas, assume, for the purpose of this conversation, that my cap is black plastic. Do you see that? So division of power 91 says silver metal is competent to the Parliament, whereas black plastic, of course, analogy, you won't see silver metal in the Constitution, right? Whereas black plastic is competent to the province under 92. Now we need to make a bottle, a silver bottle. Only black plastic caps can ensure that whatever we put in this bottle doesn't spill. Do you see that? Do you see the incidental and, more importantly, the rational connection? Do you see that? So my bottle is completely silver metal. If I had my way, I will make the cap silver metal as well. But making the cap silver metal doesn't help me achieve my purpose, because whatever I put in my bottle will spill. So sorry, province, I have to incur into your black plastic material just to get a little portion to cap my bottle. Do you see that? That's one of the finest analogies that I've been able to come up with. Or in terms of car accidents, there's a difference between a full head collision. You see a car coming, you're driving on the other side of traffic, and you run into the car. Or we both own, you know, this lane, right? We're both going, but the lane gets thinner, and just because I'm trying to get my own, you know, get to my own destination, I brush on your car a little, just a little brush on the side going on there. Do you see that? That's different from a full, I know that this is not my lane. You own the lane, but I ram right into you. Do you see that? That is frowned upon. But an incursion that is incidental and rational and necessary for me to be able to achieve, you know, exercising my competence and in my jurisdiction, then the Pith and Substance Doctrine says that will not be enough to invalidate the law. So what the Pith and Substance Doctrine says is that because my bottle, which is essentially a silver white or silver metal bottle, has a tiny black plastic cap, this black plastic cap, even though we admit that it is not within my competence, will not be enough to say that the entire bottle is invalid or was an incursion. Hopefully that makes a little sense, and when you start to read, hopefully it gets animated. So with that, you see that, you know, the Pith and Substance Doctrine allows for some necessary and rational incursion into, you know, each other's areas of competence. And what ancillary powers in the US is that, okay, if you need what the ancillary powers, the way that it operates in the US is okay, if you need black plastic caps to make your bottles, maybe you should also just own a bit of black plastic cap as your area of jurisdiction. But Canada says no, it's still not your area of jurisdiction. However, every now and then, if you need it in a way that you're able to convince us that it is rationally connected, then we will allow you not to own that competence, but such that it doesn't invalidate your law or your exercise of your own jurisdiction. Right? So in short, brief overview, what you should know is ancillary powers are not recognized in Canada. They are not operated in Canada. Instead, what we have is incidental powers that recognizes incidental incursions that are rationally connected in the exercise or to the exercise of, what is actually your competence and your jurisdiction, in one line. Hopefully that makes sense to you. Okay, the next chapter. We're already way past time. I apologize, guys. Even though I don't know that we had a conversation around the session being from 10 to 2, or rather from 12 to 2 or 10 to 12. So anybody who feels the need to fall off can fall off the call. It's being recorded. It'll probably be on YouTube, free to access. So don't feel the need to stay on even though you're tired. But be aware that once I get tired, we're shutting down. Okay, what's the next chapter?
Paramountcy.
Paramountcy.
So please don't get tired.
I need to get tired so you can come and pay for my intensive classes. What do you think? Okay, paramountcy. Did you say paramountcy? Paramountcy. And what paramountcy is, again, brief overview, is that, again, like the example that I gave you of a traffic law also being a criminal of law. Do you see that it's traffic, but it's also equally the example of you're driving on the road and you kill somebody. Do you see that? It starts out, it has a traffic component, but it also has, maybe not even kill, but just cause bodily harm. But it also has a criminal component. So there are issues like that that have double aspects that are just as much subject A as their subject B. Another fine example with corporate matters, or some corporate matters. So you have some corporate matters where there is director liability. If you don't behave yourself as a director, you can find yourself in jail. Do you see that? So that is very corporate, but it is also quite criminal. Do you see that? Let me think of another example. Hopefully you appreciate the issue. I mean, a fine case, even though that will not be a brief overview anymore. Okay, let me not give you case law. Let's just give it a brief overview. There are cases or conversations or subject matters that are dichotomous in nature, right? In that they are both A and both B. And in the instance where subject matter A is competent to the federal government, to the parliament, and subject matter B is competent to the provinces, it means that both levels of government can validly lay claim to enacting legislations to those type of subject matters. Does that make sense to you? Or you guys want a water break, right? And fine example again is the traffic offenses. So the provinces can regulate legislate a regulation and say, do not drive more than 100 kilometers on this road. Do not be intoxicated or under the influence when you're driving on this road. Be mindful and attentive and watchful when you're driving on this road, right? And on that same issue, the parliament is able to say, if you drive on this road and you are involved in a collision and you break somebody's leg, you're going to jail. Do you see that? So it's both of them can legislate. That creates a situation, because remember we said that there's exclusivity, but it's also not such a difficult situation because they're laying claim on different subject matters that are competent to them in their capacity as, whatever level of government that they are. It's just that they're approaching the same issue from different directions. One is approaching it from traffic and property and civil rights, the province, whereas the parliament is approaching it from criminal. Do you appreciate that? And where that happens, so long as there's valid, there's jurisdiction, the province is able to establish its own jurisdiction validly, enacting this legislation on PCR, for instance, the traffic law. This road is a road in our province, right? And the parliament is also able to enact to say, you just killed one of our citizens. Do you see that? This isn't a conversation of province. This, or rather, it can be a provision of province because it's a provincial road, but it's equally a Canadian citizen who just died. Do you see that? So when that happens, in Canada, it's called the ultimate harmony. There won't be an issue. Do you see that? And hopefully you can appreciate how you have double jeopardy going on there, except that in criminal cases, there is an express prescription against double jeopardy under the charter. But for civil issues, or I can't think of, for instance, you can have criminal penalties and then still answer to the province in a civil nature. Do you see that? Right. So when that happens, there's the ultimate harmony. But there's an issue when there is a conflict or there's a contradiction. Remember, we said that the parliament has competence to enact. The province has competence to enact. So the province has said in its competence, in its powers of legitimate authority, it has said, Seun, you must sit down. Now the parliament in its competence and its authority also says, Seun better not be sitting down, better be running. Do you see that conflict? And so the situation is, we see that both of you have power, right? We see that you have the authority to enact these legislations. However, there's a contradiction. Seun doesn't know who to listen to. Seun, if she complies with the province, will be in breach of the federal law. And if she's in compliance with the federal law, she will be in breach of the provincial law. Do you appreciate that contradiction, right? And so the court have had to establish the paramountcy doctrine to help resolve issues like that. To say that where there is competence on both levels of government to enact a law, and they have in fact enacted that law, and there is no issue, like they are aligned, then it's fine. Go and comply with the law. Go and comply with both levels of government. So for instance, one level of government says for you to advertise in Canada because television and media is competent to the federal government, $9,000 licensing fees, right? Alberta says for you to advertise in Alberta on our local airwaves under our property and civil matters of a general local nature head of power, you must be licensed with the Alberta Media Agency and you must pay $4,500. What the court will say to you is, we see no issues. Pay the federal government their $9,000, and whilst you're at it, also make sure you pay Alberta their $4,000. Do you see that? But where the parliament says, I can't think of an example. For instance, you can only advertise from 2 to 5, and the federal government says you can only advertise after you've paid and you've gotten your license. The federal government says you can only advertise from 2 p.m. to 5 p.m. Alberta says you dare not advertise from 2 p.m. to 5 p.m. You can only advertise from 10 to 11 p.m. There's a problem. If you advertise from 10 to 11, you are in breach of. Do you see that? Do you see that contradiction? And so that necessitated. Again, this is very high level. This is not very detailed, but I'm just trying to help you, get some context. Then the court established the federal paramountcy principle, and in one line, as it sounds like an English word, paramountcy, federal paramountcy, what that doctrine says is that in those situations of competence, dual competence, but contradiction, the federal law takes paramountcy over the provincial law, just like it sounds. What is paramount is what is superior. So if there are issues like that where both laws are valid because the enacting bodies had competence, but there is a conflict. If there's no conflict, remember, you'll be sent home to comply with both laws. But if there's a contradiction or a conflict or a frustration of federal purpose, then the provincial law will be kind of like frozen, not repealed. It's not a bad law. It was properly, legitimately, enacted. So it's not repealed. It's not struck off. It's not a bad law. It's just kind of like put in abeyance. It's just on hold. And the federal law is in operation. So that's that conversation you have under operability. Which law should be in operation? Because there are two competent laws in operation, but they are both conflicting. So the court needs to answer the question of which should be. Both are valid. It's not a question of which has the force of law. They both have the force of law. But which should be in operation? The federal paramountcy doctrine assists in answering that question. Next topic, please.
The interjurisdictional
immunity doctrine. This usually is very tricky for candidates, but again, like it sounds, interjurisdictional. We know that international means 2 or more nations, right? Something that affects 2 or more nations, or that is existing in 2 or more nations. And so interjurisdictional means that an entity is subject and answerable to both jurisdictions. An entity is subject and answerable to the federal level of government as well as the provincial level of government. And so because of that interjurisdictional nature, it needs some immunity because it's being pulled in different directions. The federal government says go, the province says come. So at some point, it must be able to go to the courts to ask for some saving, to say, please help me. I admit that because of my nature, I am answerable to both the federal and the provincial government, but the pool is now going to strangulate me. The pool is now going to impair, which means adversely, negatively affect an essential part of my existence, right? So courts, you need to grant me some immunity because of my nature as an interjurisdictional entity. Hopefully that makes a little bit of sense, and that assists you when you start studying. But that there is what interjurisdictional immunity is, right? The federal government has powers to regulate you. The provincial government has powers to regulate you. A fine example would be interprovincial transportation companies. Interprovincial transportation companies, you move people from Alberta to BC, for instance. BC can tell you, going forward, no yellow cars in our province. Or, Alberta says, do you see that? Or the federal government says, henceforth, all interprovincial transportation companies need to all have blue cars, right? So you're now there stuck, and you have to be able to have some recourse. And so what happens with interjurisdictional immunity is that those type of federally regulated undertakings or interjurisdictional entities are able to approach the courts to say, I'm originally answerable to the federal government because of the nature of my business, in that I'm interprovincial. Remember when we're talking about the trade and commerce of the part, to say once it's interjurisdictional, then it has to be lifted up to the level of the federal government. So I'm originally answerable to the federal government because I'm interjurisdictional in nature. However, I do acknowledge that the seat of my business, the major, all of my business activities are carried on within provinces. So I must also comply with provincial laws to an extent. Because I'm interjurisdictional and regulated by the government does not mean that if Alberta says this road is 80 kilometers per hour, you should go and drive 100 kilometers per hour. You still must comply with some provincial laws. Do you see that? However, where provincial laws will adversely, negatively affect a vital part of your operation, then you're able to go to the courts to say, I'm federally regulated originally. I see this provincial law validly enacted. I don't have a problem with the validity of the law. It's a good law. The province has the rights to prescribe the road traffic limits, right? Or whatever the issue is. However, this law, if this provincial law applies to me, it's going to ruin my business, or it's going to negatively affect an important part of my business. So court, can you please apply or trigger the interjurisdictional immunity doctrine for me and immune me, only me, from the application of this provincial law, such that this provincial law is valid, it applies to every other person, but it doesn't apply to me. That there's a conversation around interjurisdictional immunity. Okay, everybody looks tired. Everybody looks tired.
I'm not tired.
Okay, what's the next chapter?
Part 3 now, Aboriginal rights and constitution.
Okay, I'll take all three together.
Okay.
Right, I'll take Aboriginal rights, Aboriginal title, and treaty rights, and duty to consult. Do we have duty to consult there? I'll take all of that together.
Yes.
Before now, of course, all of those were one topic, and candidates were always scrambling. Which one is title? Which one is rights? Which one is duty? So it's fine that they've broken it down, but it's still the same one conversation of how does the Constitution impact Aboriginal peoples in Canada? Your statutory authority there is Section 35. It recognizes and guarantees or entrenches Aboriginal rights, still existing Aboriginal rights in the Constitution, in that it elevates Aboriginal rights to constitutional status. Do we appreciate that? And quick overview, because we're not even halfway through our list of chapters, and you're already yawning and dozing off on me, is that, and more importantly, I need to give you a reason to come and pay for my classes, is that, Aboriginal peoples, of course, we all know the history. I'm assuming that Aboriginal peoples were the first people here. They lived here. If you ask me, even though I'm being recorded, they own, the land that is now referred to as Canada. But we know how the Europeans were, at the start of the, I believe, 17th, 18th centuries, going around and conquering lands and taking on, people's stuff, right? And so for that reason, Aboriginal people have been treated shabbily. Of course, we know this, we know the history. I mean, we still see evidence of the history till date. The discovery of, a shallow grave where 300 Aboriginal children were buried. We still see those things, and it's not so far-fetched. A lot of us are probably from countries that were colonized by the Europeans, whether it's Britain, whether it's France, you see. So it should be easier for us to relate to. And so because of all that shady, shabby, everything short of humane treatment that went down with the Aboriginal people from the hands of the Europeans, Canada got to a point where, of course, it decided, oh, we apologize for all that bad treatment. We want to reconcile. And one of the first and strongest indication of that reconciliation is the inclusion or the introduction of Section 35 into the Constitution of 1982, right? To say that now we want to treat you guys as equal. We want to protect your right, because before then, those rights were administered at the pleasure of the courts. An Aboriginal person could go to court to say, random example, this isn't real. I'm a girl, my father is dead. He has XYZ. I don't have any brothers or any siblings, but my father's siblings want to take up this property. In our culture, a girl is entitled to inherit her father. You see something like that. And then the court will say, who are you? Where in our laws, we don't have that written. Do you see that? We don't know your laws. Your laws are not written. We don't even understand your language. What exactly are you talking about? Goodbye, you don't have a case. Do you see that? It was very dependent on the discretion of the court. Sometimes they would recognize the rights, sometimes they would throw them out of court. And so one of the finest things that Section 35 does is that it has been entrenched, those rights have been entrenched in the Constitution, and so the courts are bound, do you understand, to acknowledge, to recognize and administer those rights. Real quickly, what your concern should be is the test for establishing Aboriginal rights. Anybody can stroll into court and claim, I'm an Aboriginal person, and in my tribe, we always fly on trees. You can make any claims. Do you see that? But you must be able to establish that right. And I have my strong thoughts on, because I'm wondering why it should still be quote unquote European/Canadian courts that are coming up with the test to establish that the courts have laid down a test that must be established or must be proven for your claim as an Aboriginal person to be recognized as a valid Aboriginal right. Do you understand? So you want to look into that. And pretty much what it is that it must be an activity, what you're claiming, like flying on trees, must be an activity that is of central significance to your heritage, to your culture, to your group as an Aboriginal person. So quick example, because there's one of the NC questions that I had to review with somebody. The right to protest is not an Aboriginal right. Everybody has a right to protest. Protesting is not of central significance to anybody's peculiar culture. Do you see that? But once you start to see things like, oh, this stream is our, we all know these things. Those are our forefather stuff, kind of things like that for Aboriginal people. We worship this tree. We burn incense. We fish from this particular river. Do you see those type of things? We perform these rites every full moon, during the winter. Do you see those type of issues that even you're able to appreciate that the only reason you do it is because you're an Aboriginal person? It's peculiar to you because of your culture, because of your heritage. Then, you're one step in. And then more importantly, you must be able to establish that that practice has been in existence pre-contact. Very important. You must be able to establish the nature of the right, that it is peculiar and intricately linked to your culture and your heritage as an Aboriginal person. And you must also be able to, meet up with that time frame requirement. It must be something that you've done since time immemorial. Do you see that? From time immemorial, I'm trying to look for an example we can all relate to, but I appreciate that we're all diverse, so there might not be one example that we can relate to. But for instance, an Aboriginal person can say from time immemorial, our forefathers have always, the water they drink on the first day of winter, they always go to fetch it from this stream in. Do you see that? Do you see that? Now, because time immemorial is too is too vague. The courts have now tried to establish a specific time which has to be pre-European contact. So what we're essentially saying is that before you guys came on our land and scattered everything, we have been doing this. So you need to be able to establish those two, very important, the nature of the activity and the fact that it is something that has been part of their culture or their way of life pre-contact, pre-European incursion, right? I apologize to those of you who have, whose inclinations or feelings on this Aboriginal and colonization topics are different from mine. I'm sure you can hear my mindset. I'm unable to be objective on that issue. But there, as far as the NCA course is concerned, you need to establish the rights by proving, in accordance with the test that the court has laid down. Please review Aaron Sparrow. Very important, even though that's not where the test was laid down, but it gives you fine context, So please review Aaron Sparrow and definitely Vanderpitt, because that is where the test was established. Do you see that? That's for rights. We move quickly to title. Title, unlike rights, is also a right, but is a right that attaches to land. That's the difference. Aboriginal rights is, their right to do things, to perform rites, activities, fetch, hunt, fish, sacrifice, worship. But title, like it sounds, is an interest or a right in land. Do you see that? And again, there's a mouthful of conversation, but what is the most important is the test. You can't just stroll into courts to say, oh, all that land from Brampton to Guelph is ours. Do you see that? You need to be able to establish and convince the court that really there's probably some credibility to what you're talking about, to your allegation or to your claim. And the test there, who's able to give us the test? Because I feel like I've been talking too much and you guys are sleeping off.
Aboriginal title.
Yes, for Aboriginal title.
Aboriginal title is only endured in the community, in the tribe. It's not like Aboriginal rights, which is individual.
You're talking about the features of Aboriginal title.
Okay.
The features of Aboriginal title is that it is, it is vested in the community, it cannot be disposed or divested by individuals. It doesn't emanate from the crown. Because remember, they own the land. It's not as if the government, like you and I, if we buy land now, it's the crown giving us an interest in land for XYZ number. For Aboriginal title, it doesn't emanate from the crown. It's their land. But the crown is kind of like the custodian. Do you see that? Those are the features, and absolutely you should look into that. But I'm more particular about the test. And the test for title there is exclusive occupation, pre-sovereignty. Do you appreciate that? Exclusive occupation, you must be able to show the court that we have, again, they don't say own. Some of the issues, things I have an issue with, it's their land.
We've been in this land before sovereignty.
But what the verbiage that the court has intentionally used is occupation. Exclusive in there means that even if you were not there continuously, you occupied it such that any other person who wanted to occupy it needed your permission. Recognize that this place is for this tribal group, but because of course Aboriginal people are nomadic, so they can be here for summer, there for winter, and that won't be just miles or hundreds of miles away, right? So even if we're not here presently for winter, all the other surrounding tribal groups must acknowledge that the Silcotin tribe owns this or occupies this land. They're not here now because every winter they go to worship their grandmother in Cochrane, but it is their land, and for us to do anything on this land, we need to get the permission. That is exclusive occupation. Hopefully, you can also appreciate the fact that it doesn't have to be continuous. There could be breaks in chains of in the chain of occupation, in that you're gone for 5 years, you went to worship your grandmother, or you're gone in different seasons.
Is that the same thing with by surrender? Is that the same thing with surrender?
No, that is not surrender. Surrender, what you have going on with surrender is that Aboriginal people, and we will get into that with treaty rights, just like it sounds, they surrender willingly. To say that British or English crown people, government officials, the way that I like to explain it, because I feel very strongly about it, is that the English, and I might be wrong, it's just a simulated example, all in my head. The English has introduced smallpox virus into their community. it's killing all their children. Now the English are chilling, waiting in the offices, waiting to see that this smallpox virus is going to kill you guys, deal with you guys so much you will come running back to us. So the Aboriginal people come running back to the Europeans to say, we've never experienced this type of illness before. It defies all of our medicine and our herbs. You know, can you give us, and we see that it's not affecting your own children. You have a vaccine or you have a drug, an antibiotic for it. Can you please share your antibiotic with us? And in exchange for that, all this land from Calgary to Edmonton to, you see that we will give it to you. We will surrender it to you in exchange for your vaccine. Voluntary surrender. So where surrender becomes important, and because we're giving a high overview, I didn't want to get into all that detail, is that rights, whether to activities or to land, rights and titles that have been surrendered are not part of those that are recognized by Section 35. If you have surrendered, it's goodbye and God bless. It now belongs to the government. It now belongs to Canada. So the conversation of surrender will come up under extinguishment. How can Aboriginal rights be extinguished? Either by voluntary surrender or by constitutional amendments.
Oh, thank you.
See, you should have paid for my intensive class to get that. But hopefully you appreciate that. So you see those, and that again, so that we don't waste time. That again is kind of like what treaty rights look like. Initially, they were not written. But in recent times, they're reduced to writing to say, in exchange for this, we will give you that, right? In exchange for guns, automated guns, instead of our stones and our spears, we see you have these guns that make it easier for you to kill us or to kill and hunt for animals, whereas we are throwing spears and stones. If you give us, 4 cases of guns, we will surrender our rights to fish in this particular body of water. Do you appreciate that? So that is surrender. But what is very important, or what I was trying to get at, were the tests. You need to appreciate the test for establishing Aboriginal rights. You need to be able to appreciate the test for establishing Aboriginal title. And I was saying that exclusive occupation, pre-sovereignty, rights is pre-contact, land title is pre-class.
Sovereignty.
Right. And I think we've touched on treaty rights as well. I mean, what that is agreements. You have them typically as land use, or also in recent times, they're referred to as land use agreements, right? There's some that are even, that have constitutional status that have been introduced as one of those. The Constitution of Canada shall include, do you see that? So just land use agreements to say, if you do this, we will let you do that, things along those lines. And there's a bit of a history along treaty rights where the Crown was acting very, very, very dubious, very shady, very fraudulent, right? So that you would have had a conversation between, they would have had an oral agreement, because of course the Aboriginal people who didn't speak English talk more of writing. So you'd have had maybe that scenario that I painted where the Europeans have introduced some virus into their community. I apologize if I'm wrong, but that's just the way I choose to see it. Introduce some deadly issues into their community, wait for them to come running, the Aboriginal people to come running back to the Europeans, and then the Europeans say, that land that you say is yours, and we've been trying to get you off, and you're not getting off that land. We know that there's oil there. I mean, they won't say that to the Aboriginal people the way that I have it in my head, but they probably, they probably know that there's oil there ready to be explored, some money to be made. The Aboriginal guys don't know this, are probably not even in the position to explore oil. Do you see that? And so the Europeans say, give us that land and we'll give you antibiotics that will save your children. Right? Now we have that agreement. Maybe that land is all of Calgary. The Aboriginal people, of course, because they're tight, hard pressed, say, oh, absolutely, take Calgary, give us the antibiotics. Now, the Crown goes back in reducing that agreement into writing. The Crown includes Edmonton in the plan to say the Aboriginal people have voluntarily agreed in exchange for our antibiotics to surrender all that land referred to as Calgary and Edmonton. So Aboriginal people show up on their Edmonton land ready to farm and hunt and fish. And they're probably law enforcement officers, they're saying, get out of this land, you have surrendered it to the government. And they run to the courts to say, yes, we had an agreement, right? But what we agreed to was Calgary. we don't speak English, we didn't write the agreement. The Crown went back and was fraudulent, in these terms that they've captured. Do you see that? And that was happening over and over again. And so the court came up with this idea of the honor of the Crown. The honor of the Crown. So the court says the next time we get a treaty or an agreement where the Aboriginal people say that the terms of the agreement has placed more burdens on them, or it has created more expansive benefits for the government than what their understanding of the agreement was, we will interpret that agreement in a way that favors the Aboriginal people. Does that make sense to you? And hopefully you can appreciate the thought of the court in coming. Yes, because you see the uneven power, play there. You're the big brother, and every time you have to share the meat, your younger brother says you're cheating. So as the mom, I'm saying the next time you split the meat, your younger brother will pick first. Something along those lines. Do you see that? So that's that concept of the honor of the Crown, where the court was saying, we choose to believe that the Crown is not being fraudulent. We choose to believe that the Crown is not abusing the fiduciary relation. In fact, it was the court who established that fiduciary relationship to say, Crown, you need to appreciate that the relationship that you have with these guys is a relationship of trust. There's an uneven power play. You've stressed them so much. You've abused and maltreated them so much. Now that you say you're apologetic and you want to reconcile, you need to assume a position of trust. You need to assume a position where you convince the Aboriginal people that whatever you do will be in their best interest. Do you see that? And so you have that conversation of the fiduciary relationship between the Crown and the Aboriginal people. You have the concept of the honor of the Crown, where the court is saying where there's an interpretation or there's an ambiguity or disagreement between the Crown and the Aboriginal people in terms of the terms of an agreement, the court will always adopt an interpretation that favors or is more aligned with the position of the Aboriginal people, right? And then that fiduciary relationship and that honor of the Crown concept also now feeds into the conversation of the duty to consult and accommodate. To say that, in fact, now this isn't just a fiduciary relationship. These guys have rights that have been entrenched in the Constitution. Their rights are now of constitutional status. Now, whilst we appreciate that those rights are constitutional status, we also appreciate that they might not be absolute rights. We appreciate that for the greater good of, the entire Dominion of Canada, government, you might need to, take some things away from them and, give them, interfere with their preferred way of exercising some of their rights. That's the language. Interference with the preferred way of exercising or enjoying Aboriginal rights. Now, where that happens, or where you want that to happen, then you must comply with certain tests, or that would trigger certain duties on your part as the government. And there you now start to have the conversation of, for you to interfere, for you to, deny them of a right or take on their title, then you must convince us that there is a legitimate, compelling legislative objective. This is no longer a high overview, but hopefully you guys appreciate and you're following through and you understand, you have a reason for some of these things. To say that this is their right, is constitutional, but if you must take away that right from them, then you must convince us that, there's a compelling reason why you're doing that. And if you do that, you must consult with them. You must, have a sit down with them to say, this is our issue, this is the dilemma we face. Canada is running broke. You own this land. We acknowledge that you have an established title to this land. However, there is resource in this land, whether gold or oil or whatever, that can assist with generating revenue for the whole Canada. Have that consultation with them, right? And we're thinking, or we're looking at, taking over this land to explore it for oil or for gold or for whatever, or to create a bridge or to create a dam to generate electricity. Do you see that you must have a reason, a compelling, important enough to breach their rights, their constitutional rights? Do you see that? Then you must have that conversation with them to say, this is what we're thinking of doing. What do you think? How best, or how do you want to achieve this? How best do you think it will work for you? What do you want us to do that will make you feel better? Just that respect. Do you see that? And whilst there is that duty to consult, I must say here in 2 seconds that there is no constitutional duty to agree. So there's a constitutional duty on the part of the Crown, of the government, to consult, but there is no constitutional. If you consult, if the Crown consults and the Aboriginal people say this land is it holds such cultural sentiments, you know, we feel such sentiments, attachments to this land, we don't want to let it go, the Crown cannot be held to ransom. So you can still proceed and do your drilling, do your exploration, even though you consulted and he said don't do it. However, if you proceed, then you must accommodate. Hopefully you see how these things fit into each other. And accommodation just means if you proceed and you start to explore their land against their wish, and you start to make oil that generates hundreds of millions of dollars for the country a year, then they must be the first partakers. I'm sorry, that's probably Bible language. They must enjoy from that, and not just in the way that the regular Canadian will, but in the way that, you know, is explained, because this is their stuff. You took their stuff away from them. So you probably have accommodation agreements that say, you know, every year we'll pay you 13% of whatever revenue we generate from the oil that was, you know, explored and sold from this your land that we took away from you. Something along those lines. Hopefully you appreciate that. There's a whole lot more to be said. Case law, Haida Nation, seal cutting. You need to appreciate those cases properly. There's a conversation of the quantum of the duty. It's ingredients, it's not fixed. If it's an established right, then of course the quantum of the duty is high. If it's a shaky, just allegation, we own it, but there's not yet like judicial pronouncement. Do you see that? Then the duty is a bit lower. You will still consult, but you're not too invested. Do you see that? Or instead of 13%, you can offer them 6% because they don't have a clearly, you know, established rights. Do you see that? So you need to, when you study, you need to have those thoughts at the back of your mind. When are these rights triggered? And the simple answer to that is once you interfere with their preferred way of exercising their rights. You don't have to completely deny them. Just that in the mornings we like to swim, and you are saying please swim in the afternoon, the right is triggered. Those duties are triggered, right? Now the duties are triggered. What is the quantum of the duty? Then you start to get into how well established are these rights? How well established is this title? You also have the conversation of when will the Crown be said to have notice of an Aboriginal rights? So there is express notice and there's constructive notice. So the Crown cannot go ahead and just do as they please because, oh, but nobody told us that you guys own this land, or Aboriginal people have a stake or an interest in this land. Do you see that? But when you go to study, you see all of those. Pay attention to constructive notice. Pay attention to the quantum of the duties, when the duty is triggered, and of course, the tests for Aboriginal rights and Aboriginal title. Okay, next chapter. Which would be somewhere in the charter, yes, yeah. Because we're done with Aboriginal rights. So with the charter, I mean, I probably should abandon the syllabus at this point and just give you a brief overview because the charter is essentially one large conversation. And so you probably start out with interpretation of the charter. And I believe we've talked a bit about that when we're talking about federalism. And I said that, of course, for the court to be able to hold anything up against the Constitution, the court must understand the Constitution, which means that the court has the duty to constantly interpret the Constitution. Do you see that? And we talked about the principle of interpretation. And I mean, the examples that are giving you the progressive principle of interpretation, liberal principle of interpretation, purposive principle of interpretation are more at play when you talk about interpretation of the charter of the Constitution for charter reasons, like interpreting provisions of the Constitution that relate to charter rights. Do you see that? Right. So I'm not going to dwell too much on principles of interpretation, but pay attention to it when you study because you can get a tricky question there. You have the conversation of the living tree principle. You have cases like same-sex marriage reference. I don't know if that is in the syllabus, but pay attention to that case. Very interesting case for principles of interpretation.
It's in the syllabus.
Okay. Pay attention to that case when you're reading interpretation of the charter. Then you probably have let me consult application of the charter.
Yes,
I think we can be done in yes, good application. And what application means in 2 minutes is, who does the charter apply to? Who does the charter apply to? A fine way to aid your reading is to divide it into benefits and burdens. Of course, you know that with every right, somebody bears the burden, somebody enjoys the benefit. So with charter rights, I have the charter right to life, liberty, and security of person. I'm enjoying the benefits. Don't interfere with my bodily integrity. Don't limit my liberty in any way. Did you see that? And don't do anything that threatens my life. I'm enjoying the benefits. But somebody bears the burden. Do you see that? The government is there saying, if you annoy me, I will kill you. Do you see that? And the charter is there saying to the government, you cannot kill her because she has the right to life. So somebody bears the burden of containing and curtailing, restraining themselves or the exercise of their powers to ensure that my rights, are enjoyed by me. So when you're reading application of the charter, read in terms of the benefits and of course, just off the top of your head, you know that the government bears the burden of ensuring that those rights are protected and are not infringed, and the citizens, enjoy the benefit. There's a lot more conversation to be had in terms of what is government, who is government, right? Can an individual person be classified as government for the purpose of, application of the charter? And in what instances will that happen, right? There's also the conversation of, clearly, does the charter apply to individual citizens of the country? And I got that question. Remember I told you my exam was 10 6-mark question. That was one of my questions. It was something along the lines of, when you had opened a boutique and she needed a salesperson and she put up an ad, salespersons apply within, no male. Applications from men will not be considered, something along those lines. And the question had said, Seun, okay, maybe not Seun, Aaron is a guy, he wanted to apply, and the application, the ad says men should not apply. So Aaron felt like his charter right was breached or infringed. His charter right of equality, his charter right not to be discriminated based on his gender, right? So what should Aaron do? Anybody, real quick? Okay, because we're out of time, Aaron doesn't have a case because this is the charter, and the charter only applies to relations between the government and the citizen. Do you appreciate that? So individual members of the citizenry cannot be quoting the charter against themselves. Your best call there is to refer Aaron to the Provincial Human Rights Code or Tribunal. So if Aaron is in Alberta, let him go to the Alberta Human Rights Tribunal. They'll probably be able to address his issues, but it cannot be the charter because the charter is only applicable in terms of burden to the government. Do you see that? Right, so when you study that, you see all of that going on there. You see your cases there. You see Eldridge, very important case, and the Vancouver transportation case where students wanted to campaign and put their student election ads on municipal buses. You see that you get into the details of those. Then you have override of rights. In one line, override of rights is, I believe, provided for by Section 33 of the 1982 Constitution. And what it says in one line is that we see all the charter rights. And we see that, we appreciate that they're there to contain the exercise of governmental powers. However, in certain instances, the government is able to override these rights by enacting legislations that clearly invoke the provisions of this Section 33 to say that, notwithstanding the provisions of, and there are specific sections of specific charter rights that can be overridden. Not all charter rights can be overridden. There's academic conversation to say, is there superiority between the charter rights? But that's, if you read it, it's cool, but it's not so important because some can be overridden, some are untouchable. And I believe the ones that can be overridden are 2 and 7 to 15, I believe. Section 2 of the charter and section 7, 8, 9, 10, 11, 12, 13, 14, 15.
2, 8, 7 to 15.
Yes, do you see that? So only those can be overridden, right? And just like it sounds, override means we know that ordinarily these laws will be struck down for contravening section 2 and section 7 to 15 of the charter. However, we are invoking the provision of Section 33. If we had time, I would have said, let's read directly from the Constitution. It says that notwithstanding, the provision of blah, 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 the Parliament and the provincial legislation of the legislative assemblies of the provinces are able to enact legislations, that will still be valid and in operation despite the provisions of 2, 7, and 15. So what you need to do is appreciate that, read case laws that will show you, and your case law there will be Ford and Quebec, I believe. Ford and Quebec, where Quebec had said all ads should be in French language, something along those lines. So you want to appreciate what the court had said in terms of how that invocation can be done. What does the government need to do to have properly invoked the operation of Section 33 in relation to that particular legislation, right? And we move, I believe the next should be limitation of rights, I believe. And what limitation of rights is, again, quick overview, brief overview, is that, like we said with Aboriginal rights, take note, Aboriginal rights are not charter rights, right? But like we said with Aboriginal rights, yes, they are constitutional rights, entrenched, guaranteed, recognized by the Constitution or in the Constitution, but they are not absolute rights. Do you appreciate that? The government, for good reasons, for compelling reasons, and if it complies with certain steps, can validly limit those rights. Do you see that? Same with charter rights. If we had the time, we don't have that time. We're almost 3 hours in for a free session. Anyway, if we had the time, I would have invited us to read Section 1. Before you start to study limitation of rights, read Section 1 of the Constitution Act 1982. Read it. That's the basis. It's not the Oakes test. The Oakes test is just a case law where the court laid down a test that allows the court to properly animate and apply Section 1. But the reason for, your limitation, conversation when you're reviewing a legislation or action on charter grounds is Section 1, because Section 1 opens up and says, these rights are here are guaranteed, something along those lines, guarantees the right, and in the same breath goes on to say, and can only be limited,
that
as prescribed by law. Pardon? Do you have it? Do you want to read it?
And demonstrably justified.
Yes, as prescribed by law, as can be demonstrably justified, in a free and democratic society. So it guarantees it. Says, yes, you have this right. But, even though it had a negative language, but essentially what it means is it can, if that limitation is prescribed by law, and it can be justified, demonstrated to be justified in a free and democratic society, then it can be limited. Do you see that? So I have the right to life. But if I take a club and I smack my husband's head and he drops dead, oh, definitely that your right to life will be limited. Do you see that? You have the right to expression, right? But if my way of expressing myself is to sexually assault or improperly touch somebody, oh, your right to be limited. Do you appreciate that? So pay attention to that. Essentially, the conversation of limitation of right, to say that this right, we have this right. Yes, you have the rights to be a decent human being, right? But those rights can only be enjoyed, within certain ambits. Do you see that? And also pay attention to the fact that in a judicial review situation on charter grounds, the appellant, or rather the applicant, which would typically be a member of the citizenry, Seun, Onye, Erada, you bear the right of establishing that you had a right and your right was infringed. Whether that limitation is justified is for the government to prove. So it's the government's business to prove that, yes, we sentenced or we sent Seun to, or the criminal code says, if you kill, you are going to jail. You murder somebody, you're in jail for the rest of your life, right? And yeah, we see how that limits or impacts or breaches your right to life. However, we did that for XYZ reason. And there you now have the Oakes test. Appreciate the facts of the Oakes of R versus Oaks. Don't just read the Oaks test. So you can see why the court came up with that test, right? There must be, a substantial objective. In the instance of Seun, who knocked off her husband's head with a club and he dropped dead, Seun cannot be left in the community to be roaming about knocking off everybody's heads, right? That's good, substantial legislative consideration. We need to ensure the safety of, other members of the society, and we cannot leave a head knocker on the loose. Do you see that? Then we move to, is that measure? Because, and these are conversations that are not, you cannot have in brief overviews, because I like to give you the why. I like to open it up, like why do you have this? What does it mean? But yeah, read your Oaks, R and Oaks. Don't just extract the Oaks test. Read R and Oaks. Appreciate the Oaks test. Before you start to apply it to laws, apply it to random situations around you. If you're a mother, look at your children. I have 2 boys. The younger one comes to me saying, my older brother smacked me. Of course, you shouldn't use your hands. Don't smack him. He has a right to bodily integrity. However, what did you do? Why did he smack you? He smacked me maybe because I didn't shut the door to the washroom whilst I was pooping, and the smell was, I apologize for those of you that are squeamish, right? Now you want to weigh his offense, side by side, his punishment. Is the offense of forgetting to shut the door proportionate to a smack across the face that has left his left eye swollen? Do you see that proportionality? Is there a rational connection between him smacking his brother for forgetting to, maybe because maybe he was playing his game and the smell, the stench from his poop came and he just, yeah. But is there a rational connection between, you took my cookie, so I didn't go to, okay. I'm trying to look for something that's very arbitrary. You took my cookie, so I messed up the wall. Maybe I used my marker on the wall. How does that, him taking your cookie, how does it lead to you marking my walls, defacing my walls? Don't try it. Do you see that? So you see rational connection. That's, I believe, the second leg of the test, or do you see that? What's the measure? What's the issue you're trying to curb? What's the measure that you have enacted? How does it, is it arbitrary? Does it make sense? Do you see that? Minimal impairment. So he didn't shut the door whilst he was pooping and you smacked him. Couldn't you have just yelled at him to say, hey, can you please shut the door? Or can you turn on the vents in the washroom? Do you see that? Because whilst that achieves your purpose, it's also respectful of his rights. It's minimally, inclusive into his right. That's minimal impairment there. Right? Because if my younger son had come to say to me, yelled at to shut the door because I was pooping, of course I would have said, did you need somebody to tell you that? And that limitation would have been justified. Do you see that? But you smacking him on his head, yeah, it makes sense, it's rationally connected, but it's not minimally impairing. That offense was too little for the punishment. Do you see that? And those are the thoughts, and things that you need to be appreciative of when you're studying limitation. Apply to mundane situations around you. Then transfer it to legislations, your review of case laws, So for this reason, the court said X, Y, Z. Why? Do you see that? Why did they come to this court? And then you'll be super skilled and, more importantly, very confident when you're accosted with a random, never seen before legislation in the exam hall, because it's second nature to you. You have a deep, innate understanding of it. I can apply it to my children, right? I can say to myself, okay, you have an objective there, okay, I can see what your thought process was in trying to achieve that objective for doing this. However, don't you think that was a bit excessive? That would be your, minimal impairment. Or proportionality, right? Is a life imprisonment sentence not excessive for maybe omitting to renew your driver's license? Something along those lines. Do you see that? If I'm omitted to renew my driver's license and I'm driving on the road with an expired license and I haven't crushed anybody's cars, broken anybody's legs, and then a police officer stops me and says, can I see your license? You're driving an expired license, and the immediate sanction is life imprisonment. That is ridiculous. Do you see that? Even though we see your objective, you're trying to ensure that only licensed people are on the road to protect, you ensure safety, you know, we see the connection. You need to deter people from driving with expired licenses so that you can achieve your objective of protecting and ensuring safety. However, it is not minimally impairing and it is grossly disproportionate. Life imprisonment, grossly oversized, and you know, too high-handed for driving with an expired license. Hopefully we get that. And then real quickly we get into the rights themselves. I'm not going to, you know, waste any time on the rights themselves. I'm just going to point you to rights that I think you should pay extra attention to. And number one, of course, will be your Section 7 rights. Pay attention to your life, liberty, and security rights. Don't read it in passing. Dig deep. Read your Magentala cases, the both of them. There are two cases, 1980 something and 1960 something, I believe. Read both of them. I mean, you need to read that case any which way because you also need it for division of powers, right? And of course for charter rights. Appreciate, I mean, of course, I believe that at this point you all appreciate that the reason we're having a conversation is that I have a right, the government has infringed on my right, then I report to the court says, okay, we see that they infringed on your right. Government, why did you do that? If the government is able to put forth a strong argument, then that limitation is justified and I have to go and live with that limitation, right? Which is why we have the limitation test. But for Section 7 rights, there are two limitation tests. It's not just one. It's not the Section 1 Aaron Oaks test. Your Section 7 test, your Section 7, I don't have the time. I would have invited somebody to read Section 7 as an innate internal justification test or limitation test that says that, you know, these rights can only be denied in accordance with the principle of class?
Fundamental justice.
Fundamental justice.
Fundamental justice.
So you have to apply that test first, your principle of fundamental justice test first, before you now proceed to your Section 1 Aaron Oaks test for Section 7 rights. Right? Which is why you cannot read your case law on Section 7 in passing. You cannot read it as just what did the court hold. You have to see how the court applied first the internal test, the principle of fundamental justice test, and then the Section 1 test. And one question that the NC has been given quite often now is for you to share your thoughts, critique this style of applying two limitation or justification tests to one right. Like, does it make sense? Is it not redundant? You know, the NC has been asking that. Why do we need to apply? Why does the court still feel the need to, you know, do the Section 1 analysis despite, you know, the inclusion of the principle of fundamental justice analysis in Section 7? They have that same conversation going on for Section 15 right, because Section 15 right is a negative right. Do not discriminate. So why are we still limiting it? If you say don't discriminate, don't discriminate. There's nothing to justify. Do you see that? And so the NCA keeps asking, or they have been asking, you see why you cannot study for the NCAs now, which is what I believe this entire syllabus review was focused on. It wasn't anything to do with the topics or the cases. It was just to resensitize candidates to the fact that business as usual won't cut it anymore. And there's a full paragraph there saying, don't come and reproduce boilerplates, answer frameworks. I've always maintained constitutional law, you cannot use answer. It has to be organic. I have to see your mental juices flowing whilst I'm reading your question. You are a justice of the Supreme Court. Yes, you can reference textbooks, renowned authorities, but you will need to see your reasoning. Do you see that? So that's a question to pay attention to. I'm not going to answer it on the scope. Pay attention to it whilst you're studying. See if you can come up with a justification for why the court does that. It's not a conversation. That is the position of the law. The position of the law is that you apply two tests for Section 7, and you still apply your Section 1 test for Section 15 rights, no matter how redundant you think it is. In fact, in the entire jurisprudence, as far as I know, it's just one case that the court, you know, found a limitation justified, the limitation of a Section 15 right justified because of the Section 1 limitation test. And that case, I apologize, I don't do well with memorizing titles of cases, but I believe it's something along the Nurses of Labrador, some case about the union of nurses in a particular province, NAPE. Anybody seen that case? Okay, you haven't started to study, but when you start to study, you see it in your section 15 conversation. The Union of Nurses that said the government was discriminating in terms of pay on gender basis. Male nurses were earning more than female nurses or something along those lines, or female nurses were earning more than male nurses. And of course, that was the Section 7 equality, right? Do not discriminate on the basis of gender, right? And it went to court. And of course, it was a clear conversation of, yes, there's a discrimination here. Government, go and fix the discrimination. But the court, in applying Section 1, asked the government, what's your substantial legislative objective? And the court and the government said, we're broke. Simply. It's not that we don't see the discrimination or the disparity, but at the moment we cannot afford to match up the pay. And the court agreed. The court said, if you're broke, what will we do? Will we compel you to go and steal money that you don't have? Do you see that? So as far as I know, that's the only case where the application of Section 1 reversed the decision of the court in a Section 15 analysis. But I digress. The reason I flag that is to say that that's a question that the NC has been asking now, to ask you to critique that. Don't you think it is redundant for the court to be applying, two tests in Section 7, Section 1 in Section 15? It feels redundant. The court rarely changes its mind. So you see that there's absolutely no way you want to speak to that question without referencing this case I just mentioned. Even though I apologize, I can't give you the title because I don't do well with cramming titles of cases. But when you go to study, you see it. It's something NAPE versus Nurses of Labrador or something, or Newfoundland or something along those lines. Okay, with that, if you ask me, I'm good to go to the remedies because we're way past 3 hours. This was supposed to be a 1 hour, max 2 hour session. And I cannot even understand why you will come back to pay for my classes. Hopefully you do. Remedies. Important conversation to have with remedies, and of course you know that they're authorized. There's 2A, religion and conscience. There's 2B, expression. I only highlighted those two because they're quite tricky. Section 7 and 15. So pay closer attention to them. That's not to say don't pay attention to expression, religion. I'm just saying pay attention to those two more. Right now, remedies. I'm also going to give you in 2 minutes so we can be done. The provisions of the Constitution that inform remedies or that give the court the jurisdiction to award or apply remedies to Section 52, which says that Onyinye or somebody read it to us, the Constitution of Canada is the supreme law of Canada, and any law that is inconsistent with that Constitution is null and of no effect. That there's a remedy. If we do our division of power analysis and we find that you enacted something that you didn't have the competence to enact, then your law is of no force and effect. And then you have Section 24. So what that also tells you is that Section 52 is clearly worded in relation to laws. Any law that is inconsistent is null and of no effect, 52. 24 says, can somebody read 24? Do you have it real quick? You seem to have your Constitution opened. Or Obina, please. Thank you.
So 24 says anyone whose right of freedoms has guaranteed. Yeah.
Do you see that? Has been. So you must have suffered a damage. Do you see that? You must have suffered a grief or a grievance. And it says whose rights or
freedoms.
So you see that it's also quite, tailor-made for the Charter rights and freedoms. Do you see that? Charter rights and freedom, and it cannot be prospective or in anticipation of a breach. If your right of freedom has been,
have been infringed or denied, may apply to a court of competent jurisdiction to obtain such remedy as the court considers appropriate and just circumstances.
The court considers appropriate and just in the second. Doesn't give you any specific, it just gives the court a wide range of discretion. Unlike 52 tells us what you should do. It's null and of no effect. And there's a mouthful of conversations to be had under 52 as well, in terms of the numerous variations of remedies that the court has come up with, to address quote unquote bad laws. Because there is a deference that the judiciary pays to the parliament, and so the judiciary is not quick to call a law null and of no effect. So they will read in, they will read down, they will severe, they will trim and prim and prune just to try to save the law. So you see all of those when you go to study. One particular remedy under Section 52 that I should highlight for you to pay close attention to is the temporary validity, or what's that remedy? A suspension of an order of nullity. That's what it is. So the court has looked at the law. It is bad. It cannot be saved either by reading in, reading down, severance, whatever. It's a bad law. But the court is wary of immediately pronouncing it to be a bad law. So the court says this law is bad, but our pronouncement, our declaration that it is null will not go into effect until February 2022. Pay attention to that. I don't want to speak too much to it. Pay attention to that. Read the Shachter case, Shachter versus Canada. It gives you the test or guiding factors that the court must consider before the court is able to give such a post-dated, for lack of a better way to put it, a post-dated order of nullity, right? But those are variations of, the Section 52 remedies, and a lot of them are just, attempts by the court not to tear down a law, not to strike down a law, because the courts are deferring to the parliament. And the reason for that is that the courts have the opinion that the parliaments know the law. The parliament adopted the constitution, allowed for the constitution. So it's not likely that they're deliberately, and maliciously just enacting laws that are contravening the constitution. So before the court makes an express declaration that a law is bad, it must have tried to read it down, severe, try to tweak and, edit and revise. If it's not working, then the court says null and of no effect. But that is for laws. For 24, charter rights, where your rights and freedoms have been infringed upon, either by a law, which is why I said for charter, you're reviewing both. For division of powers, it's always strictly a law. But for charter right, it usually is both. It usually is both. You most likely will have a conversation where the law is good on charter grounds, but it's the discretion, the way that the governmental actor decided to exercise the discretion that the law granted. So a law is good. The law says police officers, you have the powers to arrest. That's not a bad law. But the police officer now comes into my house on the authority of that law, and in trying to arrest me, even though I'm not resisting arrest, batters me up blue and black. Do you see that? Our review will start from who even gave you where did you get the authority to come into my home to arrest me? Maybe Police Act. We'll look at the Police Act. What does the Police Act say? Does the Police Act say batter them? Right? No, it doesn't. It just says arrest. That's good. However, this discretion, this is the way you exercised it, and that was, infringing or that in turn limited my rights to security, for instance. Do you see that? So 24 says, where I'm able to convince the court, first, that I have this right. Second, that this right was limited. And that third, that limitation is not justified. Do you see that? Then the court of competent jurisdiction, of course, that goes without saying, is able to award me a remedy as it considers just and appropriate in my situation. So no specifics. The court has a wide range of discretion. It could be an order compelling the police force of Canada, whatever they're called, Royal Mounts, I don't know, to issue a public apology to me in the newspapers or on TV. It could be compensation. You must pay for all our hospital bills and then some, maybe $200,000, right? It could be damages to say, both general, specific, I couldn't go to work, my children didn't go to school because I was battered, and even punitive to discourage the police force from doing that again. Say, police pay $2 million. Do you see that the court has a wide range of powers when it comes to remedies that are provided for under Section 24? With that, I'm not even going to invite questions from you. I'm just going to say thank you for your time. Hopefully this was helpful. I really apologize. We're headed to the fourth hour. We shouldn't have taken this long. I just usually get so carried away and passionate. And hopefully that this is enough to chase you to your books, to start a study and to start to make sense of it. And hopefully it's also good enough reason for you to come to my conference. It was good to meet all of you, at least for those of you that turned on your cameras, and those of you whose voice I heard, who contributed, read out for me, or answered a question, or asked a question, or, contributed a comment. Thank you very much for your time. Hopefully it was good use for your time, and I wish you all the best with the exams. Let me also advise on one that the January diet is very tricky because everybody's fired up in November, first week of December, and then towards the second and third week of December, I'm usually begging people to come to class because everybody's in Christmas mode. So be careful, with the January diet. If you choose to write in January, don't get carried away with the festivities and the celebrations, or study ahead. Have a good grasp before second week, so that you can relax and know that once January comes, you're good to go. That's just my observation from working with clients, particularly for the January diets. There usually is a loss of momentum towards the end of the year. And before you know it, it's the second week of January. It's time to write the exams, right? Okay, thank you very much, guys. I will say you guys were not as engaging as I usually would have, but it wasn't also tiring to speak with you, right?
Thank you. Thank you so much.
Yeah,
We
thank you,
appreciate
Seun.
it. Yeah.
Thank you so much.
Have a great day, guys. Of course, the recording will be available on YouTube for anybody who wants to take a listen for free, right? You can go back to it. And hopefully I see you guys in my intensive classes.
All right. Bye.
Bye-bye.
Bye.
Before you go, please, this is my first time here. You talked about your intensive class. I don't know, how does that work? How does it go?
So we have a website, but if that's too hectic for you, you can send me an email to seun@nciguides.com. Let me put it in the tab. And I mean, even if you don't come from my intensive classes, if you have a question, you want to pick my brains a little, I will try to respond to your emails if I get them. I believe this is my email address, seun@nciguides.com. I can give you my personal one as well. If you don't reach me on the NCA Guides one, you definitely reach me on this one. So yes, if you have any inquiries, maybe about intensive classes or just random questions, if you choose to self-study, don't go and pay another tutor and come and be stressing me and taking my time. Ask you. Okay, I should stop funny.
So in that project matter I discussed with you some weeks back, now that you've been called and your schedule has become lightened, would you be able?
Why do you think now that I've been called, my schedule is lightened? You soon find out.
I don't know if you have started work immediately, right?
Oh, I have. I didn't take a break. I just moved from being an articling student to being a legal counsel. Aren't you happy?
So are you now in a better?
Very happy. Very happy.
Pardon?
Will you go back to Ontario? You are now in a better to stay.
No, Alberta is my first love.
Okay.
So I'm able to work remotely. I mean, I might have to make trips, but essentially
remotely. I was wondering maybe you want to do the transfer of license to Alberta or something like that.
I will. I will just to have that, but I don't have to. I'm not pressed to need it.
Since your work is in Ontario and it's remotely, you don't need it. But if you want to work better,
I don't need it.
If you want to practice in Alberta, you must do it, which is double money. Which is
my reluctance. I'm like, if nobody's offering me, if I'm not ready to change my employment,
yes, if you're getting good offer, it's not worth it for the double money. Congratulations, huh?
Thanks, guys. Thank you.
So can we contact you later?
Oh, sure. I put on my email addresses. I put in my personal.
No, based on that matter we discussed some weeks ago.
Oh,
right?
yes, one. Absolutely. Please, let's talk. Absolutely. But I mean, anybody who has questions, first and foremost about my intensive classes. But I mean, once you start to study as well, maybe towards the exams, you need some clarification or issues or help, I will use my business judgment to decide whether I want to.
I can't see your email address. I don't have access to the chat box. I'm just looking on the webpage. Can you say that again?
Let me spell it out to you. SEUN.
Okay, 1 minute.
At ncaguides.com.
Okay, is that the one you sent emails to us?
Exactly, the one where I sent you the link to.
Okay, no worries then.
All right.
Thank you.
All right, have a great day ahead, guys.
Okay, you too.
Take care. Bye.
You too.
Yeah, bye.
Bye.
Thank you.
We are NCA Guides. Every year, a significant number of foreign-trained lawyers immigrate to Canada, and hundreds of Canadian citizens return to Canada after obtaining law degrees abroad.
Upon returning to Canada, they have to get their credentials assessed by the NCAs and write several equivalency exams before being eligible to be admitted to any of the respective provincial bars.
The NCA exams are examinations very similar to those taken in the Canadian law schools. They're fact-based and open book examinations that take 4 hours to write. They're currently administered online.
These exams, which are graded on a pass or fail basis, are done without any help of the NCA. This is where we come in.
I have written and passed the Canadian Administrative Law exams.
I have taken and passed the Canadian Professional Responsibility examinations.
I have written and passed the Canadian Criminal Law examinations.
I have written and passed the Canadian Constitutional Law examination.
I have written and passed the Foundations of Canadian Law examination. We have all been through these examinations. We understand the difficulty that the NCA examinations present, and we help candidates overcome these difficulties and obstacles in understanding the course materials and the exam formats.
We do this through intensive classes, revisions, spot test and exam review workshops. We do not believe in a one-size-fits-all approach. Our study sessions are focused on helping candidates understand the course materials in a way unique and personal to achieving their study goals.
We have a great track record and excellent results from our past and present candidates. If you're writing the NCA exams and you want to pass them all at your first attempt, join our classes today.